Today is our third session webinar on the workshop on interactions of tax, trade, and investment. And today we will be discussing dispute resolution. We have already in the first session discussed the kind of the theoretical background, and we have looked at possibilities how the tax, trade, and investment have taken place and have been approached by scholars. The second session last week, we discussed about digital tax and digital trade. And this session today will have the dispute resolution. Next week, we will have tax incentives. And the final, the 1st of July, is an open session also with policymakers. All sessions are being recorded, and we try to make as much as possible to comply with privacy and regulations. So in case that you don't want to be in the recording, please just turn off your camera. The recordings will also be available, so we also share the recordings. And perhaps the most important is to tell you who are we, for the ones who have not known who we are. So my name is Irma Mosquera. I'm from Leiden University, and we have a project, GLOBTAXGOV, that investigates global tax governance. And together with the Council on Economic Policies, Agustin Redonda and Hildegard, and with Julianne Chase from the City University of Hong Kong, we are organizing this series of events. Today will be the moderator and the convener, Professor Julianne Chase. So I will give just a word perhaps to Agustin to introduce the next session. And I'm not sure if Hildegard is here, but I will try to find whether she can also introduce herself. Agustin, please go ahead.
Thank you, Irma. Yeah, it's a pleasure to be here, and we have been working on the topic of tax expenditures, tax incentives with Irma particularly for a while. So we're happy to have set this series of workshops. As Irma said, next week, same time, we will be focusing on tax incentives for investment and the interconnections with international trade. So yeah, a bit of digitalization too. Very happy to invite you to take part in next week's section, and yeah, looking forward to today's session as
well. Thank you, Agustin. I believe Hildegard has not joined us yet, but last week she discussed the digital trade and taxes, and was very important topic, especially because of the discussion of the G7 on the minimum tax, and also we did have OECD, David Bradbury, and all the consequences for the digital trade. So today, Julianne, I will just give the word to you, and then I will stop my role as a moderator.
Thank you very much, Irma. So very good morning, afternoon, or evening to one and all present here. My name is Julianne Chase, and I'll be giving the welcome speech for today's webinar on the settlement of tax and tax treaty disputes by the International Courts and Tribunals. So as explained by Irma, this is the third event in our series of events on globalization and digitalization. In the next 5 minutes of my little speech, I'll be walking you through what this third webinar is about, how useful it is for you, or how useful we hope it's going to be for you, and what does the future hold in the context of the theme of this webinar series. So the theme of this third webinar reflects, I would say, the growing recognition of the power and importance of international courts and tribunals in international tax policy, and also the vital role international taxation plays in shaping global economic governance. As you know, formally, international tax disputes are between the tax authorities of two different countries. They result from differing interpretations of the provisions of a tax treaty between two countries, two jurisdictions. These international tax disputes mainly affect taxpayers with cross-border economic activities, usually transnational corporations, so TNCs. Now, what's interesting is that over the past 10 years, the number of new MAP cases has hugely increased, and the number of outstanding cases has more than doubled over the last years. In fact, what we observe, and what's in part motivated this webinar, the series of webinars, is that cases are taking longer to resolve. It also seems that most cases concern the allocation of profits of TNCs among different taxing jurisdictions. So for these reasons, the resolution of tax-related disputes between jurisdictions feels like an unreachable goal in today's climate of complex audits and long mutual agreement procedures. So on top of that, we get the BEPS project that we have discussed in the past webinars. And we have seen that the BEPS Action 14, which basically seeks to improve how cross-border tax disputes are resolved between jurisdictions, has not yet delivered on its promise. Rather than quickening the process, the length of time to conclude the MAP has increased for transfer pricing matters. And that's according to the latest OECD statistics. Also, it seems that some TNCs are choosing not to use MAPs or tax arbitration because it's too early to know whether the BEPS minimum standards in Action 14 are operating effectively. So all in all, these are many challenges for international tax disputes resolution. In fact, the central idea that this webinar will discuss from various perspectives is that tax controversies rise across the world, and so does the need for more effective dispute resolution mechanisms, especially across borders. Our intuition that we'll try to verify in this webinar is that there is probably a triple need. There is a need to better understand how non-tax courts and tribunals handle tax disputes. There is also a need to better understand whether non-tax courts and tribunals create solutions or problems for international taxation. In this respect, we are very interested in understanding whether there exists a dialogue, actual or potential, among international courts and tribunals on increasing tax disputes. And I say there is a triple need. The third one is that there is also a need to understand whether a more effective international tax dispute resolution mechanism is possible, and whether such a mechanism could take inspiration from, say, the WTO, investment arbitration, the European Court of Justice, or even the International Court of Justice. So that's many things. In order to discuss these issues and concerns, which are important for the future of international taxation and also for the future of international economic law, I'm delighted to welcome all the participants. As all speakers' profiles are available on the web, I'll keep my remarks as brief as possible. Let me just remind everyone that each speaker will have a maximum of 20 minutes each for his or her presentation. I also want to thank in advance the lead discussants who have joined to share their knowledge and experience. And they will help to ensure a discussion that's, I would say, grounded in the concrete realities of international tax and international economic policy making. After each presentation, we will simply invite our lead discussants to kick off the discussion and comment on the presentations. Before coming to a close of these remarks, I would also like to remind you to strictly stick to our time schedule and not to let any session or any speech overrun. So I sincerely hope you will enjoy today's debate, and I thank you in advance for your participation. So let me turn to the first speaker and the first presentation. It's really my pleasure to introduce our first speaker for today, Dr. Prabhash Ranjan, who teaches law in New Delhi. I think that for a few weeks Dr. Ranjan will be at South Asian University until he joins Jindal Global University over the summer. So let me seize this opportunity, Prabhash, to congratulate you on this new role and on this new appointment. Prabhash will talk about investor-state dispute settlement and tax matters, which is an issue that has attracted huge attention, in particular in Asia Pacific, given the two recent awards rendered by investment tribunals in the cases involving Vodafone and Kent. And the two cases were against India that lost these disputes. So I now hand over the floor to Prabhash for 20 minutes. Over to you, Prabhash ji.
Thank you so much, Julian. Good evening, good morning, good afternoon, wherever you are. It's an absolute honor and a privilege for me to be part of this panel discussion, and I'm extremely grateful to Julian for his kind invitation. As Julian has already mentioned, I'm going to talk about international investment law and taxation matters, with focus on two key cases involving India. And these cases are Vodafone versus India and Kane Energy versus India. Both these cases involved foreign investors challenging India's taxation measures. Now, we all know, as Julian mentioned, that international investment law is increasingly witnessing foreign investors challenging host states' taxation measures before investor-state dispute settlement tribunals. Now, there are basically two views which have been put forward on this matter. On the one hand, the contention is that the power to tax is an integral aspect of a state's sovereign power, and thus it should be regarded as part of states' police powers. In other words, the exercise of taxation measures in a bona fide manner for public purpose should be non-compensable, even if it leads to deprivation of foreign investment. Thus goes the argument. On the other hand, the argument which we often hear is that since taxation measures are like other regulatory measures adopted by host states, foreign investors are very much within their right to challenge these measures as potential bilateral investment treaty breaches before ISDS tribunals. And the argument goes further that allowing host states the sole and unfettered prerogative to characterize a regulatory measure as relating to taxation might lead to regulatory abuse. And indeed, there have been several ISDS decisions where tribunals have highlighted the concerns regarding a potential abuse of taxation powers by the state. I'll just give a few examples for your kind consideration. In a case known as Encana versus Ecuador, the ISDS tribunal recognized the state's capacity to abuse their power to tax by designing tax laws in a manner which is extraordinary, punitive in amount, or arbitrary. Likewise, another ISDS tribunal in a case known as Burlington versus Ecuador recognized that taxation can be confiscatory, leading to indirect expropriation. So the absolute exemption, and based on this, it is argued that the absolute exemption of taxation measures from the arbitral review limits the protection to foreign investment in cases of abuse of taxation powers. Now, given this sort of broader background, I would now like to introduce the two cases involving India. And before we come to discuss the ruling given by the Kane Energy Tribunal in some detail, it's important for us to understand how these two cases originated against India. The story goes back to 2006, about 15 years back, when Vodafone BV International, Vodafone's Netherlands entity, entered into an agreement with a company called Hutchison Telecommunications International Limited, which was a Cayman Island company. And the agreement was to buy 67% shares in the Indian company of Hutchison SR Limited for US $11 billion. Now, subsequent to this transaction, the Indian tax authorities slapped a capital gains tax of more than $2 billion on Vodafone. Vodafone contended that the transactions did not involve a capital asset situated in India, and hence no capital gains was taxable, whereas the Indian tax authorities contended that Vodafone's income is taxable under Section 9 of the Indian Income Tax Act, which makes income deemed to accrue or arise in India taxable. The matter went to the Supreme Court of India, and the Supreme Court of India decided in favor of Vodafone, ruling that such offshore transactions were not taxable in India, as per the law which existed in India in 2012 when this case was decided. As soon as this case was decided, India did something very, very dramatic. What it did was that it was basically piloted by the Indian executive at that point of time. It introduced a bill in the Indian Parliament which amended the Income Tax Act retroactively with the objective to overturn the Supreme Court's decision favoring Vodafone. It was very evident that this change in the law was made to overturn the Supreme Court's decision favoring Vodafone. Now, this amendment, the 2012 amendment, amended Section 9, and it said that it made the section retroactively applicable to indirect transfers, that is, to the transfer by a non-resident of a share in a company incorporated abroad, if the share derived directly or indirectly its value substantially from assets located in India. So this was Indian government's contention throughout, that even if it was an offshore transaction, the value that Vodafone derived were from assets which were located in India, and therefore Vodafone had to pay a capital gains tax. Now, subsequent to this amendment, of course, Vodafone didn't have the option of going to the Supreme Court again. They could have gone to the Supreme Court challenging the constitutionality of the amendment, but it's highly unlikely that the Supreme Court would have struck down the law on the basis of being unconstitutional. And therefore, Vodafone decided to bring two BIT claims against India. The first claim was brought under the India-Netherlands BIT, and subsequently Vodafone brought a claim under the India-UK BIT. Last year, in 2020, September, the ISDS tribunal under the India-Netherlands BIT, almost after about 4 to 5 years since this case was brought, ruled in favor of Vodafone, pronouncing that India has violated its fair and equitable treatment obligation towards Vodafone. However, our analysis is handicapped by the fact that the Vodafone award is not publicly available, or at least I don't have access to it. If any one of you have access to it, I'll be grateful if you could share it with me. So what was we know that the tribunal held that India has violated its FET obligation, but we don't know the reasoning behind the tribunal's decision. Nonetheless, this 2012 amendment to the Income Tax Act brought by India brought another indirect transfer under the ambit of India's taxation laws. And this indirect transfer pertained to the internal corporate restructuring which was carried out by Kane Energy, another very well-known transnational corporation, of its investments in India. Now, Kane, from a period of 1996 till 2006, had acquired many interests in India's oil sector. And these interests were held through different subsidiaries which were incorporated abroad. There were 27 subsidiaries to be precise. In 2006, Kane decided to consolidate these 27 subsidiaries into a new entity in India known as Kane India Limited. Now, 31% of shares of Kane India Limited were sold to the public, and Kane UK Holdings Limited, which was the second claimant in this case, held the remaining 69% shares. The 27 subsidiaries were initially transferred to Kane UK Holdings Limited, and subsequently they were transferred to Kane Energy's wholly owned subsidiary incorporated in Jersey, Kane India Holdings Limited. And finally, Kane India Limited acquired Kane India Holdings Limited from Kane UK Holdings Limited. It was this acquisition, that is of CIL, Kane India Limited acquiring CIHL, which included capital gains realized by CUHL, that became the focus of India's taxation measures. So armed with the 2012 amendment, the Indian government or the tax authorities in 2014 launched their investigation into Kane's restructuring from 2006. And as part of this, it prevented Kane UK Holdings from selling its shares in CIL, the Kane India Limited. In 2016, finally, the Indian tax authorities slapped a demand notice of approximately $4 billion to Kane UK Holdings Limited. This matter went to the India's Income Tax Appellate Tribunal, which upheld the tax demand made by the government. Kane UK Holdings Limited did not pay the tax despite this adverse decision and despite several notices being issued by the Indian government. And finally, since the money was not being paid, India engaged in the forced sale of Kane UK Holdings shares in Kane India Limited. And as a result, subsequently, Kane Energy sued India, alleging that the imposition of taxes retroactively violates the India-UK bilateral investment treaty. I know that these facts are slightly complicated, but I thought it's important for me to present these facts so that you know the context in which these taxation disputes have arisen and have been brought against India. Now, the Kane Tribunal ruled against India in favor of the investor, and luckily we have the Kane Award. And I've studied the Kane Award for the purposes of this preliminary draft of mine. The tribunal ruled in favor of Kane and dismissed India's argument that the 2012 amendment merely clarified the intent of Parliament regarding indirect transfers and that it was not retroactive. So India's argument was that this amendment was not retroactive, it merely clarified the intent of the Parliament. The tribunal was not persuaded by this argument. The tribunal held that the 2012 amendment substantively changed the scope or operation of the law, specifically Section 911 of the Income Tax Act. One of the arguments that was put forward by India to defend its taxation measure was that the amendment to the Income Tax Act was constitutional. That is, it was consistent with the Indian Constitution. The tribunal held that whether the 2012 amendment was constitutional or not has no bearing on India violating its treaty obligation, because India's liability has to be ascertained under international law, which is the India-UK BIT in this case. The tribunal further went on to say that the dispute between Kane and India, and this is a very important point, is not a tax dispute, but a tax-related investment dispute. So the tribunal tried to draw a distinction between a tax dispute and a tax-related investment dispute. The tribunal held that a tax dispute is a dispute relating to the taxability of a specific transaction. On the other hand, in a tax-related investment dispute, the tribunal's task is to determine whether the host state has violated the substantive protection standards given in the BIT while exercising its authority in the field of taxation. Now, the tribunal further reasoned that India's decision to retroactively apply the law, the tax law, without a specific justification, created a new tax burden on a transaction that was not taxable at the time it was carried out. That is in 2006, the time when Kane Energy started to restructure its investment in India. So the tribunal held that India robbed Kane of its ability to plan its activities, keeping in mind the legal consequences of its conduct. It disproportionately undermined the principle of legal certainty, which according to the tribunal is one of the core elements of the fair and equitable treatment standard, specifically, and of the rule of law generally. Thus, the tribunal concluded that India violated its FET obligation towards the investor and ordered India to pay more than $1.2 billion to Kane. Now, this was, in short or in brief, the tribunal's core reasoning. Now, we need to critically assess the tribunal's reasoning. And specifically, I would like to focus on the distinction between taxation dispute and a tax-related investment dispute. One gets an impression that the Kane Tribunal wanted to draw a distinction between the taxation measure and the application or the implementation of such a measure. Now, I am not sure how this distinction will play out in diverse situations because the line separating the two is very thin. For instance, if a foreign investor challenges a taxation measure that has been adopted, which is not disproportionate, for example, which is bona fide and suitable for a public purpose, would it be qualified as a taxation dispute between the investor and the state, or would it be called as a tax-related investment dispute? In other words, the point that I'm trying to make is that whenever a foreign investor challenges a state's taxation measure before an ISDS tribunal, the challenge is not to the measure as such, but that the application of the measure that the application of the measure breaches one of the substantive obligations contained in the BIT. And therefore, this, according to me, remains a gray area. Furthermore, if the investment treaty does not exclude taxation measures from its scope, would the tribunal still refrain from adjudicating over a taxation measure? If this approach is this a restricted approach to just taxation measures, or is this part of the police powers doctrine, of which taxation measures is just one part? Now, I'm just raising these questions because these questions come to my mind after reading the tribunal's analysis. Now, I'm almost coming towards the end. I know my time is running out. India's argument that since taxation measures are an integral aspect of state sovereignty and therefore they are outside the scope of the BIT, in my view, is a weak argument, and it was rightly rejected by the Kane Tribunal. However, the Kane Tribunal's ruling does create a possibility of ensuring that taxation measures would be consistent with countries' BIT obligations if they are imposed in a proportionate manner with adequate justification. The argument that taxation measures would be non-compensable if they are part of states' police powers is a question that remains unanswered, since the tribunal, having found that India has violated the FET provision, did not rule on other claims of the investor, including on expropriation. Now, an important outcome of the Kane Tribunal and other ISDS rulings adjudicating over taxation measures could be, and I'm saying this especially seeing India's new investment treaty practice, that states might start drafting investment treaties that exclude taxation measures from their scope completely. An important example in this regard is India's 2016 model BIT and the subsequent BITs that India has signed with countries such as Belarus, Mozambique, Kyrgyzstan, etc. In all these treaties, there is a provision which says that the treaty shall not apply to any law or measure regarding taxation, including measures taken to enforce taxation obligations. The provision further provides that the host state's decision that a particular regulatory measure is related to taxation, whether made before or after the commencement of arbitral proceedings, no So this can be an outcome of tribunals ruling or adjudicating on the taxation measures. And we might see more and more countries adopting a new kind of investment treaty practice where they push taxation measures completely outside the purview of the BIT. So with this, I'll stop. This is still a work in progress, and I'll be very happy to hear the comments of the two reviewers and other questions. Thank you so much.
Thank you, Prabhash. Thank you for giving us a very insightful presentation on these recent awards. I will have questions in particular to see how and what kind of lessons we can draw from some other countries and other existing BITs, but I keep them for the Q&A. Let me remind all those in attendance that they should feel free to use the Zoom chat box to ask questions now or when the speakers are presenting. Do not feel obliged to wait the Q&A. It's in fact preferable for us, for the moderator, to collect questions earlier in order to direct them to the speakers in due course. So now we have the chance to have two great experts in international tax and investment law in the room. The first discussant is Blažej Kuzniaki, who is Deputy Director, Strategic Advice, Tax Advice and Dispute Resolution at PwC Poland. The other discussant is Professor Noam Zamir of Catholic University of Lyon. So each of them will have up to 10 minutes to make comments, suggestions, to bring in new insights or ask questions. It's totally free. It's up to them to see how they want to use this time. Let's start with the first discussants. Blažej, let me hand over the floor to you.
Thank you, Julian. Thank you for invitation to participate actively in this event regarding fascinating interdisciplinary world of tax and investment related disputes. Also, thank you very much, dear Professor Prabhash Ranjan, for a very insightful and interesting presentation on Karn and Vodafone cases. At first, I try to share with you, all of you, some questions and comments, and then bring in additional perspectives. I think that this case, the Karn case and Vodafone case, they were mainly about the issue regarding the retroactivity of tax law. In other words, the way of implementation of new tax legislation with retroactive disproportional effect. I know that Professor Ranjan, in his written observations that we obtained a few days ago, made a distinction between the taxation measure enaction, application of taxation measure, and implementation of taxation measures. So I would like to hear later on his comments whether in his view the cases in question were more about the breach of BEAT standards due to their application, or perhaps more due to the way how India implemented the law with retroactive effect. I would say that the latter is more relevant, but I would like to hear Professor Ranjan's views. Next, the observations of the tribunal in Karn case on the proportionality of the tax measure, in my opinion, are strikingly similar to the ones of the Court of Justice of the European Union jurisprudence, for example, in cases such as Commission versus Greece, SIAD, and Itelcar. This trio of CJ-EU case law demonstrates that the suitability of anti-tax abusive measures to prevent abusive tax avoidance is not enough to ensure their compatibility with EU law. To ensure compatibility, in the court's view, such rules must be proportionate and their proportionality must be closely associated with their precision. If such rules are not clear, precise, and predictable enough to determine their scope in advance with sufficient accuracy, they simply do not meet the requirements of the principle of legal certainty. Would be interesting to hear the views of Professor Ranjan in that regard. Could, in his view, the jurisprudence of the CJ-EU on the proportionality of anti-tax avoidance measures of member states, EU member states, may be used by arbitral tribunals in cases such as Vodafone and Karn cases to decide on the breach of standards relevant to BEATs, such as fair and equitable treatment. Professor Ranjan also posed question, if a BEAT does not exclude taxation measures from its scope, would the tribunal still refrain from adjudicating over a taxation measure if it has been implemented or applied in a proportionate manner with adequate justification? My answer would be no, because to reach the conclusion that the taxation measure has been implemented or applied in a proportional manner with adequate justification, every arbitral tribunal must first adjudicate over such measure. However, once the tribunal reaches such a conclusion, that is to say that the taxation measure has been implemented or applied in a proportionate manner with adequate justification, it would mean that such measure does not breach the fair and equitable treatment standard under relevant BEAT. Finally, I want to bring in additional perspectives regarding tax avoidance and combating abusive tax practices. These issues, in my opinion, were very important in the cases in questions, to not say crucial, because of at least two fundamental reasons. Firstly, the tribunal in Karn case stated that in paragraph 1270, that it understands that the respondent's case to be one of abusive tax avoidance, that is to say, one where the form of the transactions, even if formally lawful, was chosen with the dominant purpose of reducing or avoiding liability to pay tax in ways that are inconsistent with the intent of the law. And the tribunal will address it as such. Given that the claimants were referred to it as tax avoidance, the tribunal will use the terms tax abuse and tax avoidance interchangeably, unquote. Hence, the tribunal identified the tax avoidance with tax abuse. At the same time, however, the tribunal has never, apart from paragraph 1796 of the decision, referred to an internationally recognized crucial element of abuse of tax law, which is the contradiction of transaction or arrangement with the object and purpose of the relevant tax provisions, including relevant provisions of tax treaty. This is not to say that taking into account the overarching premise of abusive tax avoidance would change the tribunal's conclusion that the arrangement of the claimants in the current case did not amount to such abuse. However, the identification of abusive tax avoidance should never be based solely or even mainly on the arguments of the parties of the dispute, but rather should be deduced from the legally binding sources, such as domestic tax law of the respondent, in that case, Indian tax law, as seen in the context of international tax law, in that case, the Indian tax treaties. The abusive tax avoidance should always be determined with the borders of legally binding sources that either determine such phenomenon or provide guidance how to do so. Otherwise, the rule of law and the principle of legal certainty can be compromised by the tribunal. And finally, the second overarching aspect regarding the proper identification of tax avoidance stems from the fact that it could lead to the significant reduction of award for the claimants, as it took place in UCOS versus Russia case, in which the tribunal determined whether the damages caused by the claimants by the wrongful acts of respondents should be reduced because, as respondents argues, quote, claimants may not recover from Russian Federation the fruits of their own wrongdoing, unquote, paragraph 1594, final award in UCOS case. In that regard, the tribunal referred to Article 39 of the International Law Commission articles on the state responsibility, which says that in the determination of reparation, account shall be taken of the contribution to the injury by willful or negligent action or omission of the injured state or any person or entity in relation to whom reparation is sought, unquote. In UCOS case, the tribunal referred to the tax optimization structures deployed by the claimants that are very interesting, in particular due to the BEPS and post-BEPS work and its anti-treaty shopping initiatives. The tribunal reviewed these tax optimization structures and saw the reason to reduce the claimed damages based on the so-called contributory fault doctrine, paragraph 1615, 1617, and 1637 of the UCOS case. Quote, having considered and weighted all the arguments which the parties have presented to it in respect of this issue, the tribunal, in the exercise of its wide discretion, finds that as a result of the material and significant misconduct by the claimants and by UCOS, which they controlled, claimants have contributed to the extent of 25% to the prejudice which they suffered as a result of the respondents' destruction of UCOS. The resulting apportionment of responsibility as between claimant and respondent, namely 25 to 75%, is fair and reasonable in the circumstances of present case, unquote. Perhaps the tribunal in the current case could also reduce the amount of award for the claimants if it identified that although the arrangement was not abusive, it was nevertheless, to some degree, an example of tax avoidance of withholding taxation in India. Regrettably, the respondent did not pursue that path in its argumentation. Instead, it followed all or nothing approach that was also reflected in the tribunal's reasoning in current case. And the final idea to ponder on, in tax-related investor-state dispute settlement cases could be an obligation that the president of the arbitral tribunal should be an expert in tax law. That's all on my side. Thank you very much.
That's fantastic, Blazej. Very interesting. I already took many notes. Without transition, if I may say, let's now hear the comment from Noam Zamir.
Thank you, Julian. And thank you, Professor Ranjan, for your paper. First, I would really like, again, to thank all the participants. I see we have 77. It's very nice to see so many people. what I would like to do briefly with my 5 or 7 minutes here is really, I think Professor Ranjan has a lot of questions now, very specific about. So I would just maybe like to share a wider perspective about this tension with tax regulations and breaches of investment treaties. And then I will pose a few questions to Professor Ranjan and to the other speakers, but of course I appreciate that you already have a lot of questions, and probably the speakers, the other participants also want to pose questions, so don't feel pressure to answer them, necessarily all of them. So, as we've just heard, tribunals have found that taxation measures can amount to an indirect expropriation, to breaches of investment treaties. And in recent years, in parallel, we're seeing a reaction, not just to these cases, but to other investor state cases, which arguably threaten the state right to regulate and to act. And I think part of this wall, when we're seeing the taxation cases, we need to understand maybe the more wider context. But some states feel that their right to regulate, to act for the benefit of the general population, for health, is under threat. Now, we have different reactions to this alleged threat. On the one hand, we see it in treaties, all kind of clauses, whether it's clauses that emphasize states' right to regulate, to impose taxes. And we see, as Professor Ranjan also mentioned in the Indian BIT, we see also exclusion of specific measures from the ambit of the investment treaties. Another reaction that we can see in cases, and this reaction again comes directly from the pleadings of states, of counsel who represent state, is the increasing reliance on the police powers doctrine, which, as we've heard, it means that some acts shall not be regarded as expropriation, and therefore the state does not need to compensate, even if the fact is that the investor, for example, lost his investment. So we see these two developments, although again, as we've noted, I noticed also in the chat, they're not necessarily new. Exclusion of taxation measures we have in all treaties. Police powers doctrine, we see also references even in older cases, but we definitely see an increase also in the discussion. So from this wider context, I would be happy to hear maybe Professor Ranjan, but also other speakers later on, if you have time, really addressing maybe the following points. So when we are talking about taxation measures, and states have this tendency to protect their right, obviously, to tax, I was wondering for Professor Ranjan, do you see any difference between the following two cases? One, a state decides to, let's say, nationalize all the foreign petrol industry, whether it's directly or indirectly with different measures. Second, the second case is a state decides to impose a tax of 19.5% on all the owners. Now, do you think that there is a reason why investment treaties, public international law in general, should treat these two cases differently if their effect is the same? Is it just, so that's really one question. And relatedly, I've noticed in your draft paper, you did mention the development in the Indian BIT model, the reaction, the attempt to exclude taxation measures. And I would be very interested to know your thoughts about this development, your critical thoughts. So now moving to more specific questions, which at least for me, they're of secondary importance, but if you have time, I will also be happy to hear your specific thoughts on that. When we're talking about police powers doctrine, and I can share with the speakers, one of the recent disputes that I've seen really from pleadings of states and investors on the other hand, is whether proportionality should be considered or regarded as a condition for the lawful exercise of police powers doctrine. Now, some tribunals said it explicitly, proportionality is a condition. We've seen it in the Philip Morris Award versus Uruguay. But I know that respondent, that states, Council representing the state, try to argue that proportionality is not actually part of the conditions for police powers doctrine. They refer to the original Harvard draft. So again, if you have, I noticed that in your draft, you did refer to proportionality. And I wonder if that means that you also think that proportionality is, or at least should be, a condition. Final question, and then I will leave the floor to the other speakers and obviously to equally important questions. When you read the cases that you present, at least the case which is published, do you think that, what was the crux, what was the real issue in terms of the illegality, if we can separate it? Was it the retroactivity of the your discretion which question to address? And thank you again for the opportunity.
Thank you very much. Thank you to both of you, Blažej and Noam. I'm sure Prabaš might already be willing to respond or add comments. I see some questions in the chat box. Let me suggest that I quickly organize the questions that I will direct a little later to Prabaš. For now, Prabaš, you might want to take 2-3 minutes to answer not all, but some of the questions raised by both Blažej and Noam. Would you like to do so? Yeah.
Yeah, I'll just take a couple of minutes. Excellent questions. Thank you very much to both of you. Firstly, on the point about proportionality, I mean, something which I talked about. I have been a little skeptical about use of proportionality analysis by ISDS tribunals for a variety of reasons. I mean, we don't have the time to go into that detail, but I'm not sure whether ISDS tribunals have the legitimacy to do the kind of weighing and balancing that is required for a proportionality analysis. So therefore, it's okay to say that if the taxation measure is proportional, it should be fine. But then, whether ISDS tribunals have the legitimacy to undertake proportionality, that's an important point. On the question of, whether we draw a distinction between nationalization of, say, petroleum industry or taxation of 95%. Again, it depends on, whether you use the sole effect test. And if you use that and you use substantial deprivation, then there will not be any difference between the two situations. Both would amount to a case of expropriation. On the question of exclusion of taxation, yes, I saw the question. I saw the comment of Professor Mann as well. My point is that while in the previous generation BITs, at least this was true for Indian BITs, taxation measures were excluded from the purview of MFN or national treatment in most of the investment treaties. But now the practice that we are seeing is there's a complete exclusion of taxation measures from the entire investment treaty. So this, I think, makes the new practice a little different from the previous practice. Whether it is a good thing or a bad thing, I don't think so. In my opinion, it's not a good idea to completely exclude taxation measures from the purview of the BIT, because at the end of the day, taxation measures are part of states' sovereign regulatory measures, and ISDS tribunals should be able to review those regulatory measures just like they would review any other regulatory measure. So there's nothing special about taxation as such. Now, if the state has enacted its taxation laws, in good faith, in following due process, etc., then it would anyway not be a breach of the investment treaty. I think in both the Vodafone and Kane Energy cases, if the change was not retroactive in nature, it is quite possible that the tribunal would not have ruled against India. It was the retroactive nature of the taxation law which I think tilted the scale towards, in favor of the investor against India in both the cases. Thank you.
Thank you, Prabaš. So let me read some of the questions we received in the chat box. Sometimes you can see it because it's sent to everyone. Sometimes it's only sent to me. So there is a first simple question for you, which is whether the tax matters for India are eligible for arbitration. So it's about the arbitrability of tax in India. And a second quick question, Patty Chongshit is asking, or is saying, if tax claims arising out of domestic tax law do not have the same cause of action as treaty, this means investors are not subjected to the fork in the road clause under IIAs or investment chapters of any FTAs. Is that correct? You can see the question, I think, in the chat box.
Yes, I can see that. Yeah. So, the fork in the road clause will again have to, whether there is a fork in the road clause will depend on the language of the investment treaty. It may not be there in every single investment treaty. And the ISDS tribunal will obviously be guided by the language of the investment treaty under which the dispute has arisen. Perhaps I'm repeating myself. I don't see anything special about taxation which should make it different from other regulatory measures, and therefore, in my view, taxation measures should be arbitrable. And if the regulatory power has been exercised, in a proportionate manner, then it should not cause a problem for the state, even if it is challenged by the investor.
Thank you. There is a new question coming in under the name WTI Zoom1. It's, of course, Peter Van den Bosch. So you have to answer this question from a former appellate body member. And the question is, in light of recent case law on the police powers exception, is there still discussion on whether measures need to be proportional or, according to some tribunals, necessary?
Yeah, it's a difficult question to answer, but I'll say that it depends on what approach the tribunal would adopt. I mean, if the tribunal were to adopt the police powers approach, then again, the question is, does it apply to expropriation only, or does it apply to all treaty provisions? This is again a question which I don't think has been answered. In most of the cases, it has been applied in context of expropriation claims, not so much in context of FET claims. Proportionality, again, it has been used in context of expropriation. It has also been used in context of FET. But again, it becomes a difficult question to answer, that whether proportionality as a principle should be used to judge violation of all BIT substantive standards, or should it be restricted just to expropriation claims? Yeah, so I don't think I've given a satisfactory answer, but this is what I can think as of now.
Thank you, Prabhash. I see more questions coming in. There is one from Frederick Heidmüller. But before that, I noted two little questions for you. The first is a clarification. The question of expropriation emerged from the back taxes imposed by the Indian tax authority, right? I mean that the tax authority seized 10% of CAN India shares, valued at around 1 billion, in pursuit of back taxes. So this is this question that went to the Indian courts, right? And later, CANS sought international arbitration for the losses over expropriation of its investments in India from the minority holding. Is that correct? And the second point, still, very much about Indian law or Indian policy. As you explained, the Indian government argued that the dispute is fundamentally about tax and not investment, right? So this would mean that the case is a domestic matter and not within the arbitral tribunal's jurisdiction. I mean, that was the rationale on the Indian side. Now, given the outcome of the case, can you give us some insights as for what India is likely to do in terms of enforcement?
Yeah, so on the first part, Julian, I think the reason for India to go for the forced sale of of Kane's shares in India was largely because Kane had refused to pay even after losing the case at the Income Tax Appellate Tribunal. And it was after this forced sale that Kane decided to bring the BIT claim against India. Now, if we compare this with the Vodafone scenario, in the Vodafone scenario, there was just a tax demand. I mean, India did not do anything to collect the taxes in the sense in which the regulatory measure that it adopted vis-a-vis Kane. So the Vodafone tribunal, as you know, to the best of my knowledge, has not awarded damages to the investor because there was no forced action as such by the state to collect the taxes which were due. But in this case, there was a forced action. There was a forced measure in order to collect the taxes. And this, I think, makes the two cases slightly different. But even if there was no forced sale, it is still possible that Kane could have, taken the matter to the BIT tribunal, just like Vodafone did in its case. On your second question, Julian, I think India still believes, even despite the adverse tribunal ruling, India still believes that taxation matters are completely outside the purview of the investment treaty. This has been the constant thought of the Indian government right from day one. But if you read the India-UK investment treaty, you will find that taxation measures are an exception only to the MFN and national treatment provision and not to the entire investment treaty. What India will do, well, India is trying its best to challenge the award so as to buy more time. And at the same time, Kane is trying to attach, Air India assets abroad, which obviously has made it very, very difficult. In my opinion, I think India should honor its award and bring these disputes to an end. But I don't think that's going to happen. There will be enforcement of the award domestically as well under the Indian arbitration law, if it comes to that stage.
Good point. Good point. Prabhash, would you be able to answer a very last question, the one put forward by Frederic, and that you can read in the chat box? Can you say it?
Yeah, just one second. Yes, I mean, if India had adopted the taxation, amendment and not made it retroactive, because India's argument was primarily about, tax avoidance in the sense that the assets are ultimately based in India, even if the transactions are offshore, and therefore capital gains has to be paid. It is quite possible that that argument can still be made even with the law that existed in 2012. But the Supreme Court finally ruled in favor of the interpretation that Vodafone was favoring. And we know that once the top court of the country has decided on a particular matter, then that becomes the law of the land. So the amendment was primarily to overrule that law. And therefore, if it was not retroactive, I don't think it would have been struck down by the tribunal or held to be a violation of India's BIT standards. It was the retroactive nature of the taxation law which made it problematic.
If I may...
All right, thank you. Thank you very much, Prabhash. I think it's time to move on. I think it's been a great discussion. So big thanks to Prabhash, Noam, and Blazesh, and to those who have been asking questions. Let's move on to the next topic and speaker. I'm now delighted to introduce Dr. Luca Rubini from Birmingham University. We'll discuss the role of the WTO in adjudicating tax-related disputes. So I hand over to you, Luca. Go ahead, sir.
Thank you very much. And if you do not mind, I have prepared a set of slides that I will share with you just to organize my little speech a little bit better. I thought that this kind of title could already give you a sense of the case law, WTO case law on tax measures, untying the Gordian knot. So according to mythology, you had this knot, which was very, very difficult to untie. And that is what I notice as a leitmotif in the various branches of the case law on taxation. I was also very glad or surprised from the previous panel to hear things which really resonate a lot to a trade lawyer. So before starting with the paper, one thing that I think will become increasingly clear during my presentation is that in trade law and in WTO law in particular, tax is not special. To put it another way, there can be no doubt that tax measures, in as much as they produce an impact on trade, that's the rationale, are covered in various shapes by various legal provisions of the GATT and then the WTO. So there is no doubt about that. And I have gathered, this is my understanding, I'm not an investment lawyer, that this might still be open as an issue in investment law. Having said so, you still have the paradox that Prabhash highlighted at the beginning. On the one hand, you typically have by the adjudicatory bodies the affirmation, the statement that members are sovereign with respect to tax matters. But just a few paragraphs after that, when you start clearly with the legal analysis of the specific complaints on the basis of specific legal provisions, which talk about tax and require a certain type of conduct on taxation. So you see here the same type of tension. Now, what is the goal of my paper? I want to investigate the relationship between tax law, which normally is a domestic prerogative, and international trade laws, in particular WTO law, through the case law. And again, this is once again rehearsing the point of the tension. But I'm not stopping only to the disputes that have been taking place so far, because to enrich the context, I will try to be quite modest in this, but I will also give a look to few topical issues which are subject to controversies, but not to litigation yet. And I will try to use them briefly as brief hypothetical cases to be tested under trade laws. Let me say immediately that following what I find in the WTO and in the GATT, I do adopt a very broad notion of tax. So this includes, and I'm here following partly a common jargon, or more specifically a trade jargon, including both border tax measures such as tariffs, duties justified in various ways, or export taxes, for example, and beyond the border, domestic internal tax measures. I will consider litigation on both direct and indirect taxation. Another recurring theme of my little research I've done in preparation for this seminar is the continuous intersection between taxation and key economic and non-economic challenges, like tax avoidance, we discussed about that, the need to keep a level playing field, competitiveness concerns, and carbon leakage concerns. So we increasingly have a mixity of these issues. So if this is the goal of the paper, well, very quickly, for those that are not conversant with trade law, but I gather that you already had one session providing the basics of trade law, so I will be very quick. These are, in my view, the provisions, the main legal provisions that are implicated in trade law by tax disputes. The first, the long bullet point list refers to the GATT, which is the acronym for General Agreement on Tariffs, Tax, and Trade. So you already see since the very beginning, the genesis, how taxation was in the shape of tariffs was a very important trade issue. And the provisions that are mostly litigated or that can come under scrutiny in tax-related litigation in the WTO are the most favored nation principle, the principle whereby you have to stick to your tariff promises. Very importantly, Article 3 of the GATT, prohibition of non-discrimination, and in particular, or if you look at it from another perspective, the obligation to accord a national treatment with respect to internal taxation. GATT 20, which includes the general exceptions. Then as exceptions to Article 2 and the obligation to stick only to the tariff ceilings of your concessions, Article 6 permits, on top of these tariffs, to impose, to levy under specific circumstances, anti-dumping duties, countervailing duties. And if you look at Article 19, there is a mistake here, is not Article 14, Article 19, the possibility to use safeguards, and the most common of those that are used are still tariffs, special tariffs. Then clearly you have subsidy provisions that are implicated whenever a tax incentive is claimed to be a subsidy. So Article 16 and possibly non-violation complaints, Article 23 of the GATT. All these basic provisions, which are still there in the GATT, were developed in the Uruguay round of the 80s and 90s, when the WTO was designed into specific agreements. And the one that is more relevant for tax litigation is probably the ASCM, which stands for Agreement on Subsidies and Countervailing Measures. Equally relevant, you will see why, could be the GATS, the General Agreement on Trade in Services. Now, my intention was to very briefly go through these types of disputes and analyze the key points and possibly provide a tentative conclusion. So the first is really those tax measures, once again, tax adopted broadly, that are applied for the simple reason that a product, a good, is crossing the border, okay? They specifically, in other words, have the intention to have an impact on trade by reducing imports or by reducing exports, okay? Normally we talk about tariffs, import tariffs. There is no regulation, general regulation on export tariffs or taxes in the GATT for the simple reason that it would not be very rational for governments to not to export, but these nonetheless happen, and in certain annexes, if you wish, to the big WTO rule book, like the protocols of accession, think the protocol of accession of China, you have specific rules on export taxes. What I will do in my paper is to quickly review the case law on tariffs, trade remedies, and export taxes very quickly, clearly, because you have a lot. But what I think will be interesting is clearly not to focus on every single issue, but it is the last bullet point. In my view, this case law shows an evolution in the use of tariffs as an instrument of protection. And you do see that, especially in the very recent years, when specific rationales are put forward in justification of the levying of the tariff, like national security or a variety of other public policy objectives. And to be sure, to be fair, these rationales did not pass the check of the dispute settlement. I'm referring to, and I will look at cases which involve the various tariffs imposed by Trump in the US-China trade war, tit for tat cases, and very important cases a few years ago, which concerned restrictions on exports, which included also export taxes. So the Chinese case on export restraints on raw materials and rare earths. So here the interesting point of this case law is the evolution of the motivation for the use of these border taxes, which normally don't have any other reason than protecting your domestic industry. Another very important chapter, and again, it is gaining, it has always been very high on the agenda, very controversial, but it is gaining a new prominence recently, is that of border tax adjustments. We had in 1970 a working party on this, which in which the GATT contracting parties outlined the basic concepts and distinctions. For example, the distinction between direct taxation and indirect taxation. That was developed into the specific export, in the specific subsidy context with an illustrative list on export subsidy, which is now attached to the agreement of subsidies. Now, what I will highlight in the paper is the political and practical significance of certain distinctions, like, as I said, distinctions on direct taxation, which cannot be adjusted, or indirect taxation, which can, under conditions, say, of proportionality, be adjusted. I will also, apart from carrying out a brief review of the relevant cases, I would also like to address an hypothetical case here, which is the case of the current proposals or so of the US and the EU on a carbon tax adjustments. So I would like to test that to the WTO rules. And interesting, probably will, this exercise will enable a deja vu, going back to issues that if only you studied trade a few years ago, were very much at the top of the discussion. Principles like the PPMs, process production methods, and the importance of the shrimp case. So where we have here a shrimp stew case concerning carbon taxes, we have to clearly wait and see. For now, in my paper, you will only have an hypothetical treatment. National treatment, as I said, is a key principle. Article 3 of the GATT is a crucial provision, is the most important provision probably, which regulates any domestic policy which is beyond the border, okay? You name it, could be in general regulation, but in our case, taxation, internal taxation. Now, the WTO, the GATT first, is particularly deferent towards members. And this article is a good example, the best example of the negative integration approach of the GATT. So you can introduce, if you wish, carbon taxes, but there is no obligation to do that. You can introduce a carbon tax, and if you do that, you can decide at what level and also the details, but there is only one commandment. You do not have to discriminate between imported and domestic products, okay? That's in a nutshell the anti-principle. Here I will overview the rich case law on internal taxation, the various requirements, and I will highlight the practical difficulties that you still have in distinguishing between what is a legitimate tax and what is a protection tax. between what in some cases is a legitimate differential treatment in taxation, and in other cases is an illegitimate one. There will also be clearly a chapter on subsidy litigation. Tax incentives are one of the most common subsidies. I don't have global statistics on that. Certainly, if you look at Europe, the scoreboard on state aid, you will see that consistently 2/3 of the state aid that is notified to the European Union takes the shape of tax incentives. And also in the GATT first and the WTO, we had very interesting cases where a lot of big pictures issues came out. So we specifically focus on the 1970s, where there was this litigation. It was a tit-for-tat litigation between the US and 3 European countries, Belgium, France, and the Netherlands, where at the core of the litigation, you really had a clash between the worldwide principle of taxation in the US and the territorial systems that you have prevailing in Europe, and on the fact that in order to ensure what the Americans thought simply level the playing field, they did introduce exception to the principle of worldwide taxation. This law was, after a very complex process and a specific memorandum negotiating by the parties in the early 80s, adopted, and the US replaced this legislation with the Foreign Sales Corporation legislation, which had a slightly different form, but the goal was the same: to remedy the inherent competitive disadvantage of a tax system like the American one, which is based on worldwide taxation and which does not enable American multinational companies to benefit, to exploit offshore jurisdictions, whereas the territorial systems do enable that. So we look at that litigation, and this very long litigation shows 3 decades the difficulties of determining whether a tax incentive is a subsidy or not. Talking in the current WTO jargon, we have 2 words to interpret, to construe, otherwise due, in the definition of subsidy, and this language has caused nightmares to the adjudicating bodies, to the extent that so far we don't have a clear statement of the law yet. This is partly due to many things. Part the fact that the structure of tax law itself is not easy, that in many cases you have to carry out a geological exercise because you have a stratification of different amendments of the laws. So it's different to understand what is a general rule and what is an exception, and also the important role that public policy objectives play in the analysis. And a tax can pursue many public policy objectives. In my overview, I will also show the different approach of lawyers and economists to this issue, the subsidy question on taxation. The legal approach is based on formalism. So you have certain legal requirements to make sense of, but these are the 4 corners of your analysis. For economists, that is not the case. They are much more flexible in their analysis. The conclusion is similar to the one that we had for national treatment. The case law, the law itself, shows a sheer degree of legal uncertainty. This is one of the last chapters that we had in the area, which is a carve out, an exception to the principle of non-discrimination of national treatment, which I just mentioned. It is an important exception in paragraph 8, which has been there since the 1940s, largely neglected till recently. I will focus on one important case of 2 years ago, the Brazil taxation litigation. And basically, what was the key issue, the key question here? Does, and I quote the language of the carve-out, the payment of subsidies exclusively to domestic producers, which are excluded from the obligation of non-discrimination, does this payment cover also tax measures? And if so, can also cover tax measures with attached protectionist elements like local content requirements? Now, the answer of the panel and the majority of the appellate body was no. This exception can only cover positive expenditure and not taxation. And what I will develop here, I can see that my time is running out quickly, so maybe we can talk about it later on. But the point I would like to make here is that I agree with the majority of the appellate body, because a different interpretation, so that also tax discrimination is excluded from the principle of national treatment, might have led to a conclusion where you don't basically have remedies for tax discrimination, neither under national treatment or under subsidy laws. So in terms of the system, I think this is a very good decision. And more generally, broad picture, what does this case law shows? The continuing attempt by governments to retain sovereignty in tax matters. The last frontier, we don't have a case yet, is that of tax avoidance. We mentioned that. There are various elements there linked with the narratives of the level playing field and competitiveness. What I will do, I would like to again use two hypothetical cases and test under WTO law the EU tax rulings cases and the digital services taxes, which are now have been subject to action, Section 301 by the United States. So, few words of conclusion, if I may, in 20 seconds. What comes out in general is an uneasy. So tax is not special, as I said, but having said that, there is an inevitable uneasy relationship between tax and trade law. A clash between the broad recognition of state sovereignty and then the specificity of explicit trade commitments. Uncertainty of the law, I would say also sometimes uncertainty of the tax systems, and legal formalism versus a more substantive assessment of economics. The importance for lawyers and for adjudicators that they have given to systemic consideration, and now increasingly we have a trade and tax and national security and climate change type of issues. The final question is really whether trade law is the best tool to regulate tax distortions, and probably the answer is not if you want to use it as the main tool, and probably this lead to the final consideration that some form of cooperative harmonization is needed, and this seems to be also the signal that certain big governments, for example, recently in the G7, have been sending out. Thank you very much for your attention.
Thank you. On behalf of everyone, I'd like to thank Luca for a very interesting presentation. Luca, I think I'll come back, in the Q&A to see what you think about GATS, and in particular the Panama-Argentina case, which I think may be interesting to explore in your paper. But let's now turn to our lead discussants. We are very lucky to have Peter van den Bosch, who is director of the World Trade Institute in Switzerland, and also James Nedumpara, who is the head of the Center for International Trade and Investment Law in New Delhi. So now you know the rules of the game, if I may say, up to 10 minutes for each of the two discussants. And we start with Peter. So Peter, hand over to you.
Thank you, Julianne. Let me first of all thank the organizers. Thank the organizers for inviting me to comment on Luca's paper, and also to congratulate them with this most timely workshop series. A workshop series that clearly appears to be a success, and that is not a given in these times of Zoom fatigue. The settlement of tax disputes by the WTO is a topic that is large enough to write more than one book about, if you want to cover all its complexity. And if only for that reason, also for other reasons, but if only for that reason, I would like to congratulate Luca with his 20-minute overview. Quite impressive. As usually, I disagree with very little of what Luca said. So let me perhaps try to make a few, I must admit, perhaps random additional remarks. Although, to be fair, listening to Luca, I'm not even sure whether they're additional remarks, because he covered most of this too. But perhaps Luca will disagree with some of my remarks, and then we have a discussion. First, I very much welcome that Luca did not only talk about internal taxation, but also refer to border taxes, such as ordinary customs duties, other duties and charges, including anti-dumping and countervailing duties, and border tax adjustments. And it's especially with regard to the latter, we may soon expect some disputes. Now, Luca referred to it as a hypothetical case. Luca, I think we're beyond this. Yeah? It's not yet a case pending before the WTO, but the dispute is, I think, clearly there, and it's going to be a huge dispute. Unless, and I try to be an optimist, unless some kind of understanding is reached on what sort of carbon border adjustment is permissible. Yeah. And one would hope that this is one of the things that will be, if not on the agenda of the ministerial conference, upcoming ministerial conference, something that will be discussed seriously soon after. Let me just say that border taxation can be, and in my mind should be, a tool at the disposal of governments to achieve policy objectives and to protect and promote core societal values and interests. Border taxation, and I think Luca also made that point, is not only about government revenue generation or protecting against import competition. It is, and certainly can be, and recently has been, much more. On border taxation, two more comments. First, there is a considerable gap, and this is a point that Luca hasn't made. There's a considerable gap in the WTO rules on border taxation. While under the WTO agreement on rules of origin, WTO members were supposed to adopt multilateral rules on how to determine the origin of products for border taxation purposes. We're still waiting for such rules to be agreed on. And it is my impression that this is somewhat surprisingly, I would say, not very high on the priority list of WTO members, and hasn't been high on the priority list for a very long time. Yet we all know that rules of origin create tremendous problems, or that the difference in rules of origin creates tremendous problems. Secondly, still with regard to border taxation, Well, with regard to customs duties on digitally transmitted services, WTO members have, ever since, when was it, 1998, repeatedly decided to maintain the practice not to impose customs duties on such services. The latest moratorium decision taken in December 2019, when the members agreed to maintain the process of not imposing such digital taxes on services until the 12th Ministerial Conference. Now, that 12th Ministerial Conference is coming up at the end of this year. India and South Africa and a few other developing countries may block a decision to further extend this moratorium. In 2019 joint communication by India and South Africa, they calculated that the revenue lost by developing countries due to that moratorium was estimated to amount to, and this was in 2017, to $10 billion US. Well, if WTO members are unable to agree on a new moratorium in late November, early December of this year, then border taxes on services may soon become quite common. Now, on internal taxation, 4 comments, if you allow me. 2 comments regarding national treatment, the national treatment obligation, and 2 comments regarding subsidies in the form of tax measures. With regard to internal taxation and the national treatment obligation, I would first of all like to say, and look, I already referred to it, but I'm not sure whether we go the same direction. I'd like to say that it would be very welcome to have further clarification of the relevance of non-product related PPMs, or non-product related processes and production methods, in determining whether products are like, under Article 3.2 first sentence and Article 1 of the GATT, or directly competitive or substitutable under Article 3.2 second sentence. Such clarification would, I think, be most welcome. And I think more can be done here to allow WTO members more tax policy space without getting into the domaine réservé of Article 20. Second comment with regard to the national treatment obligation and internal taxation. And that second comment concerns the narrow interpretation that the appellate body gave in Brazil taxation to the Article 3.8b exception for subsidies. And look, I already referred to it. This exception should not apply to subsidies in the form of tax measures. And I'm happy to hear that Luca on this point agrees with the majority of the appellate body that ruled in this way, leaving aside who was part of that majority. Now, with regard to subsidies in the form of tax measures, let me just say, and I say this from from personal experience in European Union PET, US Boeing 21.5, and Brazil taxation, that to determine under Article 1.1 of the subsidies agreement whether government revenue otherwise due was forgone is a true nightmare. As I think we all know, the tax legislation of many, if not all, WTO members is so complex and detailed that it is often difficult to distinguish general rules from exceptions. Even look at if you undertake a geological exercise. I like this wording, but even if you undertake that sort of exercise, even then it remains a huge challenge. I suppose the best one can do is, as the appellate body has done, is to look at the tax treatment of comparable income of comparably situated taxpayers. But take it from me, this exercise remains a nightmare. Final comment, and now I speak from the heart. What we desperately need in the context of the subsidies agreement is an Article 20-like general exceptions provision, which would allow to justify otherwise SEM inconsistent or actionable measures, including SEM inconsistent or actionable tax measures, which pursue core societal values and interests, such as addressing climate change. Is this too much to hope for? Perhaps. And with those rather random comments on an excellent presentation, I conclude.
Thank you, Peter. Let me now invite James Dumpara to share his thoughts and comments.
Okay. So thank you, Julian. Thank you, Dr. Rubini, and also Professor Vanden Bosch. In fact, it is very difficult to follow both these true experts in the field. I try to really look at this particular topic and the working draft with a very critical eye. And I should say that even in a short working draft of nearly 500 words, no, not 500 words, I think 2000 words with 5 pages, Dr. Rubini has been able to capture most of the issues. So when we think about the issues, these issues have been very clearly outlined. One is basically with respect to the border taxes, falling within Article 1, then whether the border taxes are actually levied in excess of the bound commitments. Then Article 2.2 that actually talks about the border tax adjustment, whether they are operate in conformity with Article 3.2, and then moving to the other categories of border tax adjustment again, like anti-dumping and CVD, and then moving on to Article 17. So it is a very, I think, in terms of the identification of where taxation has got an interface with WTO, I think Dr. Rubini is absolutely spot on. The only thing that is required in this paper is more elaboration and detailing. So now let me try to come up with the 3 areas Dr. Rubini has identified with respect to WTO and tax dispute. The one is actually tax avoidance. So this is a very important issue. And in fact, Julian in his opening remarks actually spoke about tax avoidance and obviously with respect to Pillar 4 of the OECD Action Plan. So when we think about tax avoidance in the context of WTO, the only thing which I can think about is basically a tax relief. And where can we actually find a tax relief? Maybe the tax relief can be in the nature of an internal tax measure, which can technically fall within Article 3.2 of the GATT. Or maybe sometimes, there was a decision of the US Foreign Sales Corporation where certain kind of a tax benefit also amounted to a discriminatory treatment within Article 3.4 of the GATT. But to me, I think the most important issue is basically paragraph 2 of Article 1.1 of the SEM agreement. the proverbial, the most important issue of whether the government has actually forgone revenue that is otherwise due. So, and again, a reference to footnote 1 of the SCM agreement. So this is typically the issue, and Professor Peter mentioned it absolutely accurately. Technically, the governments can tax everything, including the air that we breathe. So it is actually a question about, whether the half is half full or whether the half is half empty. It is an extremely difficult issue. Mainly in the context of, I think, a direct taxation, it is an extremely difficult issue. And I should say that, perhaps some of the issues that we encounter with respect to taxation and WTO is actually the age-old Working Party report. So the Working Party report in 1970 actually spoke about or tried to give some kind of an indication or what categories of taxes can be border adjusted. And I do not know why only indirect taxes, got the benefit of the Working Party adjustment report, whereas any kind of an exemption or a waiver or any kind of a relief given to a direct tax measure can actually amount to maybe a prohibited export subsidy. So that is actually, many people said that that distinction has to be done away with. Anyway, this is a fairly old argument, but I would actually urge Professor Rubini to examine this issue critically, because should there be a distinction between direct taxes and indirect taxes? And based upon some of the recent debates as well, most of the governments have become extremely, I think, nervous about direct taxes becoming not only part of the WTO thing, but even part of the regional trade agreements. So I had the opportunity to, work with the Indian government on the RCEP negotiation. And one of the most controversial issues was whether anything relating to direct taxation should be part of the RCEP agreement. And many countries, especially India, Prabhashan made a very good presentation on a direct tax, especially the income tax, provisions in India and the retrospective amendment. So possibly, I think most of the governments wouldn't like to have direct tax provisions as part of the WTO and forget about the regional trade agreement. So there is actually a clear exemption or a clear, I think, a clear, carve-out provision for direct taxation provisions in most of the recent agreement. This is something I think Dr. Rubini can examine in great detail. My feeling is that some of the recent free trade agreements have explicitly provided for an exemption. What is actually happening is that they provide for the mutually agreed procedure, but as Julian mentioned, the mutually agreed procedure itself is fairly complicated these days. So that is one of my comments. The second is actually with respect to, again, a primordial issue. So when we really look at the basis of taxation, we have to again go back to the border tax adjustment report. It actually provides, a clear distinction between origin-based tax system and a destination-based tax system. So in the case of a destination-based tax system, it actually provides for two categories. One is an exemption of indirect taxes, and the other is a remission of indirect taxes. It is again mentioned in Article 16 of the GATT and also in footnote 1, and a number of itemized categories within Annex 1 to the SCM agreement. Again, this is actually an issue which I think Professor Rubini can examine in great detail. Should there be some kind of a distinction between destination-based taxes and origin-based taxation within the WTO legal system? So now let me actually come to the border tax adjustment, obviously with respect to carbon taxes. So again, I think one of the complicated issues in recent times is how can embedded tax be treated? So assuming that a product is actually made using dirty materials, and is it possible to adjust these kind of input taxes, the taxes which are actually used in the upstream process, to be adjusted? That is a very interesting issue. And again, the problem is that this issue has been debated as part of the carbon tax debate as well. Again, one point which I want to mention is the reference to the optional taxes. So there's a reference to optional taxes in the border tax adjustment report itself. So, now we know for sure that it is absolutely possible to impose an indirect tax on a product. But can we actually apply an indirect tax on an embedded product? And this issue requires a bit more elaboration actually, especially from the point of view of Article 2.2 of the GATT, because that point is not very clear actually. And obviously there has been a report, the US Superfund decision, but the decision in that case is still not very clear. So I think most of the countries, so in recent times, the European Union, even India has been trying to come up with a legislation called the ROTAP legislation. So it is again a remission scheme, some kind of an export BTA. So in that issue as well, the government has been, I think, struggling with this particular point. The other important point which I want to mention is definitely related to the GATS. Obviously, I think with respect to the GATS, there is a clear reference to direct taxes, and also with respect to direct tax avoidance treaties in Article 14B, which is actually dealing with an exception. So to what extent double taxation avoidance agreements can be given some kind of a preference with respect to trade commitments is actually one of the major concerns. I don't think that we have got an issue. Julian referred to the Argentina-Panama case, but that is actually mainly with respect to an MFN treatment, but specifically in the context of a national treatment issue, whether a country can successfully, I think, invoke the exception under 14B and 14B as well. As there are two provisions relating to direct tax provisions within the GATS. So again, these are some of the issues which Dr. Rubini can examine. So now, while actually, let me come to the last point. I am pretty happy that Professor Peter spoke on that Brazil taxation case where he was an appellate body member who reviewed the decision as well. Again, I think, so what I'm saying is that this is an area where we had to look at some of the old concepts. So there's again a very old understanding that any kind of an advantage given to a consumer is basically prohibited under Article 3.4, or any kind of a benefit given to a domestic producer is absolutely fine. So a subsidy to a domestic producer is fine, but again, a very interesting issue is to what extent a subsidy can be given to a domestic producer without violating the provisions of Article 3. And we actually heard the debate between Peter and Rubini on expenditure and taxation division between this issue. My own feeling is that in a country like India, we have got something called a cess. So a cess is actually, a kind of a levy earmarked for a particular purpose. So this revenue can only be used for a particular activity, like an education cess, or maybe building a road or whatever. So my larger query is, can't we actually use some kind of, can't we use the benefit of Article 3.8b, which provides some kind of a government connected revenue to be provided as a subsidy without violating the provision. So this is a fairly interesting and a good issue to debate. So I think, Dr. Rubini has captured all the issues. I'm trying to give some kind of, I think, pointers which you can use in the elaboration of the paper. Thank you very much.
Thank you. So thank you very much, Peter and James, for your very sharp comments and questions. I already see two very good questions and one comment in the chat box. I, however, have to keep an eye on the time and we're a bit behind schedule. So, Luca, may I suggest that you try to give a concise feedback to both Peter and James, and later you can answer in writing the chat box questions. And we could come back on the WTO and tax issues at the end of the webinar when we have had all the presentation. Would that be okay for you, Luca?
Yes, perfect. Yeah.
So feel free to give any feedback now to both Peter and James, perhaps 2 minutes. Luca, you are muted.
Sorry, yes. Let me check the questions now. I thought I had to write to them in the chat.
Well, the chat questions, you can answer the chat question later. I mean, now you could answer to Peter and James. Sorry, Luca, you're muted.
I'm back. Sorry.
Don't be.
First thing, I have to thank both because their comments were very, very useful in improving my my draft. And on Peter, really, I think I agree with what he says. So I'm sorry that there is no room for disagreement in what you said. And I particularly want to reiterate, in my view, the Brazil taxation interpretation was the correct one, because the one put forward by Brazil or the minority, and here I am partly responding also to James, in my view, would have had two dramatic and negative systemic consequences. In the sense that, think about it, any tax discrimination is also a tax subsidy. In my view, that there is no difference between the two. It seems the disciplines on subsidies are quite difficult to use, even when you have a prohibited subsidy. I mean, the legal standards for contingency, the fact of contingency are not that clear. If you also take out of the table non-discrimination, you risk a scenario where you basically are greenlighting a lot of discriminatory measures. I think I will stop here. Thank you.
Perfect. Thank you, Luca, Peter, and James for this excellent presentation and discussion. So it's my pleasure now to introduce Julianne Coccott, who is our third speaker for today. Julianne Coccott holds the position of Advocate General at the Court of Justice of the European Union. And since I think 2003, she has been responsible for hundreds of cases, and she has delivered around, I don't know how many, but very important opinions that many of us have read and are still carefully studying. So it's really a great honor and a great pleasure to have you with us today to speak about the settlement of tax treaty disputes by the European Court of Justice. So without further ado, I'd like to give the floor to Julianne Coccott to address that question. Over to you, Julianne.
Thank you very much,
yes.
Julian and conference on taxes and trade, and probably slides. I have to say first, jurisdiction. The Court of Justice has only jurisdiction for matters conferred to him by the member states, and the founding treaties just do not confer jurisdiction to the Court of Justice for the interpretation of bilateral tax treaties. So the court affirmed in its case law, for example, in the Columbus container case and elsewhere, although the member states have entered into numerous bilateral conventions designed to eliminate or mitigate the negative effects of double taxation, the fact nonetheless remains that the court has no jurisdiction under the treaty to rule on the possible infringements of the provisions of such conventions. That is the rule. However, the court may interpret double taxation agreements, slide 2, acting as a court of arbitration. Next slide, please. Fine. The court, as a rule, is not competent to interpret double taxation conventions, but it may act as a court of arbitration under Article 273. It has jurisdiction about disputes between member states which relate to the subject matter of the treaties, if the dispute is submitted to it under a special agreement between the parties. The treaties do not prohibit double taxation. Nevertheless, the elimination of double taxation relates to the subject matter of the treaties, as double taxation obviously hinders doing business in the common market and makes it more difficult to exercise the basic freedom to invest in other countries. So it relates to the subject matter of the treaties, but you still need two parties, two member states that submit a case to the Court of Justice, and under Article 273, and that happened until now only once. The double taxation agreement of Austria and Germany contains such a clause, enabling the court to act as a court of arbitration, and the court rendered its only judgment under this clause in 2017, Austria versus Germany, and it had to interpret a relatively technical term, the term of Genussscheine, and it attributed the taxation power to Austria, in this case, Austria versus Germany. There are many advantages for the Court of Justice acting as a court of arbitration. The procedures of the court are public, its decisions are very easily accessible, so that case law of the court on clauses of double taxation agreements could serve as guidelines for arbitration tribunals and other tribunals, so that a consistent case law regarding those bilateral treaties could develop. That's one of the advantages, very important advantages, as mutual agreement procedures and other arbitration decisions are not so easily accessible, as we also heard today from our Indian colleague. Moreover, in this seminar, we clearly see that there are interrelations between trade law, competition law, subsidy law, taxation, and investment law. And the General Court can see all those links. It does not act as an isolated expert court who does nothing else than tax law. However, that also may be a disadvantage because the community was not so happy with Austria versus Germany. The court was criticized for its interpretation of the term Genussscheine, and it was also criticized for not giving reasons why it just said that Austria can tax those Genussscheine and resolve the so-called qualification dispute in that specific way. But do we need those bilateral taxation agreements in the European Union, or is it not sufficient to have the basic freedoms? Can taxpayers maybe get rid of double taxation by invoking the basic freedoms? That would be slice number 3. As said, the European treaties, the founding treaties, slice 3, do not lay down a prohibition of double taxation. Slice 3. So DTCs and the basic freedoms are no remedy against double taxation. There were many taxpayers tried to defend themselves against double taxation, invoking the basic freedoms, because obviously the freedom of movement within the union is made more difficult when you are taxed by several states, by more than one state. However, in order to eliminate double taxation, the court would have to delimitate the taxing powers of the various member states. It would have to allocate the taxing power to one state or the other, or divide taxing powers between the states. And as we heard at the beginning of this afternoon, the states consider, including within the European Union, the power to tax as their sovereign power. And the court therefore shies away from allocating taxing powers. As it said in the famous Block case, the union law does not lay down criteria for the attribution of competences between the member states in relation to the elimination of double taxation. Member states are autonomous to shape their tax systems. They are under no obligation to adapt their own tax systems to the different systems of other member states in order to eliminate the double taxation arising from the non-coordinated exercise in parallel by those member states of their fiscal sovereignty. That's the famous Block case, which dealt with double taxation by Spain and Germany of inheritance. taxpayers also tried to get most favored nation treatment, invoking the basic freedoms. That's the D case. Many colleagues had hoped that the Court of Justice would establish multi-favored nation treatment among all residents of the member states of the European Union, but that did not happen in the D case. In the D case, a German resident wanted to be treated the same way as a resident of Belgium. Both were doing business in the Netherlands. The German resident said it's discrimination if I'm treated differently than the Belgish businessman, because there is the prohibition of discrimination laid down in the basic freedoms. So the idea was that the basic freedoms read together with the prohibition of double taxation in a bilateral tax treaty would lead to multi-favored nation treatment all over the Union, but the European Court of Justice said no. It said that reciprocal rights and obligations apply only to persons resident in one of the two contracting member states is an inherent consequence of bilateral double taxation conventions. And such favorable rule cannot be regarded as a benefit separable from the remainder of the convention, but it is an integral part thereof and contributes to its overall balance. The Advocate General at the time, Ruiz Arabo Codonner, had voted for the establishment of multi-favored nation treatment all over the Union, but the court did not follow its Advocate General and said it's quite normal that only residents covered by the double taxation agreement receive that favorable treatment. And I think it was a wise decision of the court. So what did the court else with double taxation agreements? Abuse is a completely dominant topic now in the international tax area and also at the Court of Justice. In the famous Danish cases, taxpayers tried to reach single taxation by treaty shopping. And theoretically, you could argue that eliminating double taxation is legitimate. And so treaty shopping is not so bad if it just serves the aim of single taxation. However, eliminating double taxation is the task of the member states, and taxpayers cannot reach such aim of single taxation by treaty shopping through conduit companies or Durchleitungsgesellschaften. Even if they do this in order to avoid double taxation, that's still abuse. So, and fourth, the OECD model conventions and commentaries are becoming extremely important in the case law all over the world, including in the case law of the Court of Justice of the European Court of Justice. The Court of Justice also, as some courts around the world, but not all, the Court of Justice accepts the concept of dynamic references to the commentaries, to the model conventions. It did this explicitly in the Danish cases, saying that the concept of beneficial owner, which appears in the bilateral conventions based on that model, and the successive amendments of that model and of the commentaries relating thereto are relevant when interpreting EU legislation. So the legislator refers to what the experts may say in the future. Some people criticize this. For example, the Italian scholar Vizzioli, he says that this is not democratic. It's the matter of the legislator to make the law and not of some experts. but the Court of Justice accepts that approach, and it's not the only court in the world to accept that such references to what the experts in the OECD may say in the future. So we are here in an interdisciplinary seminar, not just taxation, but also investment arbitration. As you know, the Court of Justice, well, it terminated intra-EU investment arbitration in its famous Achmea judgment. The court has a monopoly to interpret European Union law, and such monopoly and the autonomy and uniformity of EU law is in danger if arbitration tribunals interpret union law. And this may happen when they interpret bilateral investment treaties. The court said that an international agreement cannot affect the allocation of powers fixed by the treaties, and consequently the autonomy of the EU legal system, and that observance of such EU system is ensured by the court under Article 344 TFEU. Therefore, the member states undertake not to submit a dispute concerning the interpretation or application of the treaties to any method of settlement other than those provided for in the treaties. And as a consequence of this Achmea judgment, almost 200 intra-EU bilateral investment treaties were terminated under the idea that there is no need for additional protection in view of the protection by union law and the Court of Justice and the courts of member states. Of course, the question arises whether and in how far this Achmea approach is relevant for taxation. We heard this morning, and we know that bilateral investment treaties generally have national treatment, multinational, multi-favored nation clauses, a fair and equitable treatment clauses, and a prohibition of confiscation, and also of confiscatory taxation. But there are those tax carve-outs. Sometimes they are partial tax carve-outs, sometimes total tax carve-outs. I heard this morning that there is a strong tendency towards total tax carve-outs. I would be interested to know why there is such recent tendency, but nevertheless, there can be cases left where bilateral investment treaties are applicable to tax law, and so tax disputes could arise under those bilateral investment treaties, and then we would run into the Achmea problem. This is clear with regard to intra-EU disputes. With regard to third countries, one could ask the question whether this also affects bilateral investment treaties with third countries. And so far, one has to bear in mind that the freedom of movement of capital applies to third countries. And with regard to bilateral investments, it's often free movement of capital. And so this Achmea case law may also affect investment treaties with third countries. So finally, a word on the tax dispute resolution mechanisms within the EU. I think in a former session, you already heard about the directive on tax dispute resolution mechanisms in the EU. So therefore, I will be very short. Anyway, my time is over. It covers disputes arising from the interpretation and application of double taxation agreements and provides for this mutual agreement procedure, which is, as opposed to procedures before the court, not public, and such MAP procedure is possibly followed by a procedure before an advisory commission or an alternative dispute resolution commission, and it ends with baseball or final offer arbitration or independent opinion arbitration. Baseball or final offer is just accepting what one of the parties submitted. Independent opinion arbitration is let the arbitrators reach an independent opinion worked out by the arbitrators. This procedure is a progress, but from the taxpayer side, it's still intergovernmental and with not sufficient participation of the taxpayers. Yeah, thank you very much for your attention, and I'm sorry for technical shortcomings.
Oh, no problem at all. Thank you very much, Julianne, for giving us this very insightful presentation. It's now time to hear our two discussants. I'm delighted to welcome Matteo Vaccaro in CISA. A few weeks ago, Matteo was at the European University Institute as an academic and is now the head of international arbitration at Carneluti Law Firm in Milano. I also want to warmly welcome Vasil Czorny, who is lawyer at Deloitte, Netherlands. Looking at the time, can I leave up to 5 minutes to first Matteo and then Vasil to make comments or ask questions to Advocate General Coccott? That would be great. Let me hand over to Matteo first.
Well, thank you then. I will keep it short. Thanks for being here and also to be the to serve as discussant with Vasil for the Advocate General Coccott. It's an honor, especially in light, of course, of a recent opinion on the Poland holding case versus Poland. Now, there will be so much things to say. I will just focus in light of the timing only on 4, maybe 5, but 4 very quick points on in terms of public international investment law in connection with the Austrian-German decision of the court, in order to trigger perhaps some reactions from and comments from the Advocate General and the audience, of course. So on this issue of double taxation. So the first is actually how the court retained jurisdiction on this case. And what I found interesting is that the reasoning is grounded in public international law. And I find it somehow atypical in certain respects compared to other ways and words of the court. For instance, in taking Article 273 of the Treaty on the Function of the European Union, first of all, it changed the word of the treaty in the decision. So the treaty says that the court shall have jurisdiction over any dispute between member states, and the court in the decision say it may rule on any decision, on any disputes between member states. But then it looked besides that on the provision says any according to the subject matter of the treaties under a special agreement. So the court went on under first dispute, verifying whether there is a dispute and verifying whether it is related to the treaty and verifying whether there was even a special agreement. It is very cautious approach, I'd say. And it is certainly, basically, it's like what the International Court of Justice does. In this respect, he also went on at some point in saying that, explicitly saying that domestic law is, or the interpretation of international law that is provided by domestic administrations is entirely irrelevant. And it operated on the dispute settlement clause of the German-Austrian treaty in a FEUT interpretation. And that is very interesting in connection with what are the practices in commercial arbitration as opposed to standard courts, institutional courts. I think there was also a very peculiar step in this connection, again, grounded in international law. And in light of this interpretation, that it decided to ground it on the Vienna Convention on the Laws of Treaties, as opposed discarding explicitly European Union law. Now, this is interesting, I think, because while, of course, there is reason to use international law because the court in this case was acting as an arbiter out of a treaty, a different treaty than the European Union treaties, even though connected to it, there is also, I think, it was also possible for the court to say that since we're talking about a connected treaty between 2 member states and the court was the arbiter, it could have also taken into account EU law or decided in accordance with the criteria of interpretation more typical of the court itself, which are very close. And then it looked at this interpretation through the Vienna Convention, provision sequence, paragraph 1, paragraph 2, and what was the exception to the general rule, and then it connected it to the general principles. That was very interesting, I think, again, because it was perfectly grounded in Article 31 of the Vienna Convention in almost in a conservative way, I'd say. And then to move to the third point, it reached a conclusion, and this is also very interesting, I think, that is in principle no different than the 1920s cases, Wimbledon and Lotus. So because there was an exception to a general rule established by the states in the treaty, then those exceptions had to be interpreted strictly. That's textually the text in the decision. So exception to sovereignty shall be interpreted conservatively. That is, I think, very interesting. Also from a court that has proven in many other cases to take quite of a different approach, I'd say. And then the last aspect in public international law, and then I will perhaps not use the point for the international investment law for the sake of time, is that the court, again, in terms of cautiousness, it expressly refused to issue the order that both parties take to give to the losing party, of course, in terms of reimbursing the amount improperly taken and refraining from continuing with the wrong double taxation practice. And the court expressly said there is no ground for upholding these claims. While again, here it would have been very possible, well, of course, this is pure public international law, very conservative, but it would have been also possible to say that as a matter of inherent power, if both sovereign parties to this case ask me the same order, just in opposite direction, that ipso facto implies that I have the power to do that, I think. So I'm not saying that one is better than the other, but I'm saying all this to say that I think these elements, and another one that I will not make, but prove that the court in these cases, so in terms of jurisdiction, when it operates as an arbiter on the basis of a different treaty, and also on a subject matter that, as Professor Coccott has pointed out very clearly, it's infrequent before the European Court, then it really goes back on a very cautious attitude that is purely grounded in public international law. I'll stop it here. I hope this triggered some reactions from the Advocate General or anybody else in the audience. Thank you very much.
Thank you, Matteo. Up to you, Vasil.
Thank you. Thank you very much. It's also an honor for me to comment on the paper presented by Advocate General Coccott. I just make a few brief points to perhaps open the discussion and link to some of the things that were mentioned previously. My first point is that what strikes me about this presentation is actually also the difference in the way that direct and indirect taxation is approached at the EU level. So when we talk about direct taxation, it's mostly lack of harmonization at the EU level. But if we talk about indirect taxation, for example, we talk about customs duties or VAT or excise duties, then there is a lot of harmonization, and some of the indirect taxes are actually EU-owned resources. That's especially true for customs duties, and member states simply collect the duties. So it's interesting that, yes, member states have jurisdiction, almost, well, unlimited jurisdiction, you could say, on direct taxation, let's say income tax. But on the other hand, when it comes to indirect taxes, that's very different. On the other hand, just following up on this, what I'm curious about is that I think it was said that, well, in fact, the basic EU freedoms do not really get you far in terms of avoiding double taxation. Well, what I know from my practice, and if we talk about excise duties, for example, we always use this argument, or at least try to always argue that if there's more than one member state that claims the competence to levy the duty, well, we say you cannot tax the same event 2 times. You should avoid double taxation. So I'm curious on whether that argument could in fact be used to say that, well, even some of the basic principles of EU law could lead to the same idea pursued by the treaties on avoidance of double taxation. Well, that's avoiding double taxation. So that was my first point. My second point is actually about the interpretation of double taxation treaties. I understand there is not much practice from the ECJ acting in the capacity of an arbitration court under Article 273. So there was one case mentioned. But if you think about it from the public international law perspective, so we have a double taxation treaty, and then we also know that a lot is happening now in terms of corporate taxation. We know that the statement made by the G7 on the minimum level of taxes that should be paid somewhere. We also know about the OECD instruments, that's the BEPS action plan. So imagine when the European Court of Justice looks at it and starts interpreting a double taxation treaty in that light. How does that change the interpretation of certain notions in the treaty? So I think the abuse of rights was mentioned, but also the question more theoretically. Okay, it's Article 31 of the Vienna Convention. That's that article that codifies rules of interpretation in public international law. Under what heading would some of these instruments fall? Is that legitimate, or is it state practice, or is it something else? So I'd be curious to hear views on this. And I'll stop here again in the interest of time. Thank you.
Thank you very much, Vasil. May I ask Advocate General Coccott if she wants to answer now some of the questions raised by the discussants?
Yes, I can start. Well, the first point was that the court was very cautious in the Austria v. Germany case, and I think it was just very novel to the court. It was really something really surprising and astonishing, and therefore it's probably a normal approach that you react in a cautious way, because it was really new, this kind of jurisdiction. The second remark related to the difference of direct and indirect taxation. Well, it's just, it's no wonder that we have so much case law on VAT, customs, and so forth, because that area, in fact, is quasi fully harmonized. The EU legislator agreed to make these directives, but not so in the area of direct taxation, and that's the court's case law. Is just a consequence of the decisions of the democratic legislator and of the member states. Then a third, double taxation and basic freedoms. I said that union law does not contain a prohibition of double taxation. That's only true cum grano salis. It's only true with regard to direct taxation, as you rightly said, in the area of excise duties, VAT, and so forth. The court has recognized a prohibition of double taxation, has derived it from the basic freedoms in the very old Schul case. But in addition, it does not matter so much whether there is a prohibition of double taxation or not, because the indirect taxes are so far harmonized that the EU secondary legislation attributes the taxing powers and distributes it between the various member states. And if double taxation arises, it's because of a qualification conflict, which can be resolved by a reference to the European Court of Justice, which then says this clause of the VAT directive has to be interpreted in a way that taxation powers only arise in France or in Germany or wherever, but not in two or several member states. So the problem of double taxation in indirect taxation is solved, but by attribution of jurisdictions. We do not even need a prohibition of double taxation. Yeah, and then the last point was the Court of Justice as a court of arbitration, and the legitimacy of using these OECD materials, I think, from the standpoint of public international law. that's not easy, because it's not state practice what happens within the OECD when experts decide things. It's not state practice. It's not the meaning of the most distinguished scholars. That's Article 38D of the Statute of the International Court of Justice. One can only say that these OECD commentaries or model conventions may be an indication or a reflection of state practice, because there are so many treaties with the same clauses, but then state practice from treaties is also complicated. It's not easy to classify these things into the categories of classic international law. But on the one hand, and so you can say it's not legitimate, on the other hand, maybe it's nevertheless a little bit legitimate, because there is a need for international guidance. And if you wait until state practice develops as in the old times, it may be not fast enough. Yeah. I'm not sure whether I have answered all questions, probably not, but just continue to ask in that case.
Very good, thank you very much. If I may, I see some questions in the chat box. Let me pick up one. The question is the following: how to draw the boundaries between EU and tax treaty law? Would the principle of sincere cooperation offer some guidance on this?
The difference between EU law and tax treaty law. I mean, the question may possibly arise with regard to how far the Achmea judgment goes, because when you say Achmea blocks tax disputes being resolved by arbitration courts, you have to say that interpreting tax treaties means interpreting European Union law. Yeah, but you even do not need sincere cooperation, because you would have to, you just have to apply European Union law, and you have to interpret the tax treaties in a way that they do not lead to violations of European Union law. I mean, you need sincere cooperations only where you do not have guidance. And yeah, I would have to see a real case where to understand the need to have recourse to sincere cooperation. Sometimes you need this principle, but often it's just a matter of interpreting European Union law.
Okay, thank you. So on behalf of everyone here, I'd like to thank Advocate General Coccott for a most interesting presentation, as well as Matteo and Vasil for the great comments and questions. We now move on to a new court, which is going to be the ICJ. And it's my pleasure to introduce our last but not the least speaker for today, Celine Rahman from Vienna University. Celine, it's really great to have you here today. Also, we never met in person. Had read with great interest your article, excellent article, Taxes and Custom, that was published, I think, earlier last year in the Journal of International Economic Law. It's a great piece of scholarship. So I'd like to cede the floor to Celine Rahman to address the settlement of tax treaty disputes by the ICJ. Celine, if you could present in 17-18 minutes, that would be just perfect to have a bit more time for the Q&A after the presentation. Thank you.
I will give my best to do that. Thank you very much for the floor, Julia. I also hope that we meet in person one day after this pandemic is finally over. Thank you for the invitation to speak at this workshop today. It's a great honor. I will try to save some time, but still, I would like to say good morning, afternoon, or evening to everyone who is listening. As already mentioned, my name is Celine Rahman. I currently work as a judicial fellow at the International Court of Justice. So I am currently in this building to the right of the picture you see here. I have the pleasure to talk to you about the settlement of tax treaty disputes before the ICJ, the International Court of Justice, in the next 17 or 18 minutes. As this topic combines expertise in international tax law and a core subject of public international law, I'm put in the difficult position that I have to address an audience that might be highly specialized in one of the two subject areas, but maybe not both. I personally consider myself more of a public international lawyer, and I will try to make this presentation as accessible as possible to both public international and international tax lawyers. My presentation will be structured as follows. I will first introduce very quickly my research questions for the paper that will come out of this. And subsequently, I will address each of those research questions in turn. So I will lay down the basis of jurisdiction that the ICJ may already have in the context of tax treaty disputes. I will then address the effects of a possible involvement of the ICJ and whether it is plausible that we will see any tax treaty disputes before the ICJ in the near future. And finally, I will succinctly conclude my presentation with a normative evaluation with the question of whether it's even desirable to have the ICJ decide on tax treaty disputes in the future. Let me set the stage by posing my research questions and pointing out some preliminary caveats. I will only focus on tax treaty disputes, so I will not speak about the basis of jurisdiction for possible violations of general international law, which would include customary international law or general principles of law. I will only talk about double tax treaties and possible violations of those. And furthermore, anything I present is mostly a hypothetical because bottom line is the ICJ has never decided and heard a tax treaty dispute so far. Further, there's a crucial distinction that must be made in the beginning, and I will stress this now. There is a difference between horizontal and vertical tax treaty disputes, horizontal disputes being between two or multiple states, and vertical disputes being between a taxpayer and the state. I will come back to this in a minute. Well, this is important in the context of the ICJ. And finally, a brief look at my research questions. I have 4 of them. The first being, does the ICJ already have jurisdiction over tax treaty disputes, and what would be the basis for this? Second, what would the effects be if the ICJ got involved in tax treaty disputes? Will the ICJ in the future have jurisdiction over or a say in tax treaty disputes? And is the involvement of the ICJ even desirable in this context? Let us start with the existing basis for ICJ jurisdiction, and I will try to keep this short and not too technical. The first basic point is that the ICJ statute limits the ICJ jurisdiction ratione persona to only states, so to horizontal disputes. However, a state may espouse claims of their nationals as parens patria under the vehicle of diplomatic protection. And this is interesting in the context of tax treaty disputes because there might actually be a certain obstacle for diplomatic protection here. So the vertical disputes might be brought before the ICJ, but with certain issues. Most importantly, double tax treaties apply ratione personae to tax residents of either contracting state of the tax treaties. However, on the other hand, it is settled case law that a state might only espouse the claim of their nationals under diplomatic protection, irrespective of the residence of those nationals. Hence, there might be the situation and the case where no state can litigate the tax treaty violation before the ICJ because the aggrieved taxpayer's nationality and the taxpayer's tax residence might just not align and not overlap. Let's move on to Article 36 of the ICJ statute, which contains the plausible basis for ICJ jurisdiction. Paragraph 1 stipulates 2 possibilities of ICJ jurisdiction. The first is not particularly relevant for the context of tax treaties, or not particularly interesting, because it just says that states may refer under a special agreement or compromis a specific dispute to the ICJ. The second possibility under paragraph 1 would be a so-called compromissory clause. This is more interesting. And these compromissory clauses are in specific treaties and usually vest the ICJ with jurisdiction regarding the interpretation and application of that particular treaty that contains the compromissory clause. Then paragraph 2, very quickly, contains a so-called optional clause. Under this clause, states can deposit a declaration with the UN Secretary General and thereby accept the court's compulsory jurisdiction vis-a-vis any other states which have also deposited such a declaration under the optional clause. I will now address the possible ICJ jurisdiction under compromissory clauses and the optional clause, specifically in the context of tax treaty disputes. With regard to the compromissory clause, Article 36(1), there are two types of compromissory clauses. The first being such clauses in general dispute settlement treaties, and the second being compromissory clauses in specific substantive treaties. General dispute settlement treaties are not as common and as renowned as the second type. So those general dispute settlement treaties, there's an example in the 1957 European Convention for the Peaceful Settlement of Disputes. Article 1 of this convention refers all international legal disputes between any of the contracting states of this convention to the ICJ. Advocate General Coccott just mentioned the ACMEA decision of the CJEU. This might also become relevant with regard to this 1957 convention, which doesn't have many member states, but most of the member states are clearly, or not clearly, but are EU member states. So there might also be considerations that under ACMEA, which I will not address now. So this type of compromissory clause creates ICJ jurisdiction for any kind of dispute and not just disputes related to any specific subject matter. There are currently 3 multilateral general dispute settlement treaties in force. I've listed them here. All of those 3 treaties have about 10 to 20 member states. There's also ICJ case law already on the 1948 Pact of Bogota, which has been successfully used to establish ICJ jurisdiction. The other 2 treaties, which includes the 1957 European Convention, give us no pertinent ICJ case law that might be helpful in the tax treaty context. Finally, there are about 5 bilateral of such general dispute settlement treaties, which establish ICJ jurisdiction, and supposedly, I haven't counted them myself, but more than 100 bilateral general dispute settlement treaties which establish jurisdiction for the Permanent Court of International Justice, which can now be used for jurisdiction of the ICJ. So in theory, and absent any relevant reservations in those treaties, there's no reason why those general dispute settlement treaties should not also be a jurisdictional basis to bring tax treaty disputes before the ICJ, because they usually include jurisdiction for the interpretation of treaties between the states. The second type of compromissory clauses, which might become relevant in the tax treaty context, are compromissory clauses in substantive treaties. One of those compromissory clauses might be found in the 1955 European Convention on Establishment. Again, there might be an ACMEA issue, but this convention has 12 member states, has a compromissory clause that refers jurisdiction to the ICJ, and it also includes a substantive provision on taxation, namely national treatment provision. It prohibits the discrimination between nationals and non-nationals of the contracting states with regard to taxation. Finally, compromissory clauses could, in theory, be found in double tax treaties, but we know this is very uncommon because we have the mutual agreement procedure in those double tax treaties. The only reference I found to the ICJ in any of those double tax treaties is the type that's, for example, contained in the 1992 Germany-Sweden double tax treaty, which is not a true compromissory clause, but it refers to the 1957 European Convention that I mentioned before. So it just reminds the member states we have a 1957 general dispute settlement treaty, and it shall apply to this double tax treaty. I will now very briefly address the optional clause in paragraph 2 of Article 36. So far, 74 states have deposited such a declaration to recognize the ICJ's compulsory jurisdiction. States are free to make any reservations to their declarations to limit the ICJ's jurisdiction. And in the tax treaty context, there's specifically one reservation that is interesting, the so-called ratione fori reservation. This type of reservation exempts from the ICJ's jurisdiction any dispute which is subject to another method of peaceful dispute settlement. About 50% of the declarations which have been deposited contain such a lex fori, ratione fori reservation, and thus might be a problem. However, half of those 50% of declarations which contain this reservation have a different type of ratione fori reservation, which would only exempt binding alternative dispute resolution from the ICJ's jurisdiction. Examples for this, only referring to binding, would be the reservation by Austria or Peru. In the context of tax treaties, this is an issue because there is a pactum de negociando in double tax treaties through the mutual agreement procedure. Mutual agreement procedures clearly constitute negotiations, and then in turn, negotiations are accepted as a method of peaceful dispute settlement. This can easily be seen, for example, in Article 33 of the UN Charter. So, in other words, bottom line, this lex fori reservation would likely exempt tax treaties from the ICJ jurisdiction under the optional clause. I will spend the last few minutes to address the effects and the plausibility of ICJ involvement in tax treaty disputes. I would be specifically thankful for input with regard to those questions because they're more of a socio-legal nature, and I will only give you some bullet points that I could come up with. To the question, what would change if the ICJ started deciding over tax treaty disputes? On one hand, there might be an increased awareness among states and law appliers if there was ICJ case law on tax treaties. We saw this, for example, in the context of after the Legrand and Avena cases by the ICJ, which led to massive educational campaigns in the USA to educate law enforcement officers about the US obligations under the 1969 Vienna Convention on Consular Relations. This might also happen in the context of tax treaties. Another possible effect might be the greater harmonization or clarification of the interpretation and application of double tax treaties if the ICJ gave us case law in this matter. And connected to this, this might lead to more regard for and reference to international law within the domestic application of double tax treaties. The next point would be particularly interesting for me. ICJ case law would likely lead to proliferation of public international law scholarship on international tax law or double tax treaties. So my life would be a bit less lonely in the scholarship. Furthermore, there might be, after the first ICJ tax case, there might be clusters of ICJ tax cases. This has happened before in other contexts and other types of disputes that came before the ICJ. There might be a disincentive for states to enter into double tax treaties if the ICJ took a stance and started deciding on those issues. And then finally, if the ICJ took a holistic view in any case law, it might actually lead to a consolidation of international tax law, double tax treaties. I will refer to this in my conclusion again. When it comes to the plausibility of ICJ involvement in tax treaties, my verdict would be it's quite unlikely that we will have any tax treaty disputes before the ICJ in the near future. There are two reasons for this. First, states have not displayed any appetite to have such tax treaty disputes before the ICJ, neither through existing or through new jurisdictional bases. And second, there is a general stagnation in the number of compromissory clauses and optional protocol declarations. So I see no reason why this should be different, specifically in the tax treaty context. States seem to be more reluctant nowadays to create basis for ICJ jurisdiction. Why should that be different in the tax treaty context? However, if I was asked to give a solution, if states really wanted to create more ICJ jurisdiction over double tax treaties, the best way might be to ratify an optional protocol for existing double tax treaties. Such an optional protocol could encompass an opt-in mechanism or clause to create ICJ jurisdiction for existing double tax treaties, so they would not have to be renegotiated in substance, because we know there's many double tax treaties that would be quite inefficient to renegotiate and open up every double tax treaty for jurisdiction. This could be just by reference and through an opt-in clause. And finally, this is a last consideration. It might actually be a bit more likely to have interest in consolidated ICJ dispute settlement in the tax treaty context, because new legal questions might arise in the near future, which might warrant close interpretation of existing double tax treaties. One example is the recent push by states to tax digital enterprises. For this purpose, as I think everyone in this chat room knows, a number of states have implemented the concept of a digital permanent establishment to tax tech corporations which have no physical presence in the relevant territory, but which offer services through a significant digital presence. And the US has already protested against this concept of a digital PE. And indeed, it seems necessary, or it remains questionable whether those digital PEs are compatible with the definition of permanent establishments in existing double tax treaties. So this is just a thought. Maybe there might be an interest in interpretation of the PE principle as contained in double tax treaties. I will now conclude this presentation by raising my final question, which is it even desirable to have the ICJ decide on tax treaty disputes, or are we better off to leave things as they are? There are certainly arguments against an ICJ involvement, one of them being the possible lack of technical expertise among the ICJ judges. This could be resolved through an ICJ, through a specialized chamber at the ICJ just for taxation. And clearly judges can learn, but that is one consideration. A further counter-argument for ICJ involvement would be that taxation is at the very core of sovereignty and statehood, and it might be a disincentive for states if the ICJ got involved to even conclude double tax treaties, and there might be a pushback. And finally, another argument against ICJ involvement would be that it might actually decrease the efficiency and the acceptance of outcomes of tax treaty dispute resolution as compared to mutual agreement procedures. Arguments for ICJ involvement would be that in contrast to the mutual agreement procedure or litigation before domestic entities, the ICJ is a permanent international institution and might be better suited to actually account for and see the bigger picture of double tax treaties, and that thus consolidate the case law a bit. Furthermore, ICJ involvement might lead to harmonization and modernization of international tax law, because it would be pushed back to become a bit more of classic public international law. And finally, certainly ICJ involvement in ICJ case law and international tax law would increase transparency of international tax law, which is clearly lacking at the moment under the current dispute settlement mechanisms. In some, however, it's difficult to evaluate the status quo of tax treaty dispute settlement for the lack of transparency and lack of empirical data of the mutual agreement procedure. So it would be difficult for me to say whether there could be a conducive role for the ICJ in tax treaty dispute settlement, because maybe everyone's happy the way it is. This being said, these normative questions might not even arise, because I consider it unlikely that the ICJ will hear any tax treaties in the foreseeable future. Now what's left is to thank you for your attention, and I'm really looking forward to your input. I hope I did not take too long for this presentation, kept within that 18 minutes. Thank you very much.
Fantastic, thank you, Celine. So let me introduce our two discussants. We are fortunate to have Leila Shukron, who is a chair professor of law at Portsmouth University, and Michael Motala, who teaches at the University of Toronto and will soon be teaching at Stanford Law School. Can I leave up to 5 minutes to first Leila and then Michael to make comments or ask questions to Celine Rahman? Leila first.
All right, very good afternoon, very good evening, very good morning, wherever you are in the world. Let me first thank the organizer for this great event today, and in particular, Professor Julianne Coccott. I'd like to thank as well and felicitate Celine Rahman for very interesting and certainly excellent paper on a quite complicated topic, really. It's very, very timely, as I was saying, because of the success of, let's say, the book of Thomas Piketty, because of the G7. Taxation has never been that much under, scrutiny, and we're also in the center of international debates. However, it's complicated. As Celine clearly showed, the real sort of existential node, so to speak, is the question of sovereignty. And beyond the question of sovereignty, very much that of justiciability. So why justiciability? What sort of role, what sort of function do you give to international law? And I'd like to get back in time, actually, with a quote from Sir H. Lauterpacht. So we are basically in the 1930s, and we're referring to his seminal book, The Function of Law in the International Community. So if you remember that book at that time already, he sort of he demonstrated that actually international settlement of dispute was not suitable when these disputes were dealing of a vital interest and honor. There were a few exceptions, obviously, but I think when we talk about taxation, to some extent, we are very much dealing with vital interests and honor. So to me, to respond to Celine's question at when she introduced her paper, will we see more taxation related dispute at the International Court of Justice level? I don't think so, for this very reason, and also because you can compare with international investment disputes, the very famous 4-ish dispute that the ICJ settled. Obviously, you all remember Chozo, Barcelona, Diallo, Elsie, and that was it, really, for the same reason, because it's not probably the main role of the International Court of Justice. And again, that would be really interesting to get a bit deeper into our conception of sovereignty and to what extent, and you've discussed that already in great details, but I'd be interested to hear more about Celine's view on that, the conception of sovereignty and the International Court of Justice, because to quote another authority in international law, and I'm referring to Joe Jackson, although it's been much criticized for the past few decades, sovereignty is back, and sovereignty is very much at the center of our field, investment, trade, and taxation. So as I was saying, when I mentioned Lauterpacht, because these interests are vital, because we're also dealing with the sort of honor in a symbolic manner of the state, I don't see any other development possible at the level of the International Court of Justice, but I might be wrong. Thank you very much.
Thank you very much, Leila. Michael, your turn. I think you're on mute, Michael.
Sorry about that. So I guess just to echo the other participants, I'd like to say thanks for the opportunity to participate, and as well, Celine, for your presentation. So I guess to echo the other discussant, I think, in reading the draft paper and seeing your presentation, I think there certainly is a lot of potential here, and it covers a lot of useful ground at a critical juncture in the development of the global tax regime. And I had personally not considered the role of the ICJ in the past, and I, maybe see this more of a sort of a speculative exercise or some kind of Gedanken experiment, but I certainly will in the future take into consideration. So I think, in viewing the proceedings and in reading your paper, I kind of, I think my comments sort of cohere around 4 major points. First of all, I think my high level critique of this paper, or sort of the concept put forward, and maybe more generally some of the other presentations today discussing potential dispute resolution fora, is that perhaps these papers are a how in search of a why. So, the highest level generality, it's unclear to me, what would the potential rationale for discussing the ICJ's, role in deciding tax matters be? And of course, what would the supporting evidence be to support that rationale? And I'll get to the point, about sort of the lack of empirical data about the maps. And so I think to kind of frame it, the way that I would think about it is, are we contemplating the potential role of the ICJ to the extent it might be able to assist with combating tax avoidance by multinationals, or on the other hand, would it be for investor protection or investor certainty, a mix of both, or something else altogether? And I think these sort of considerations have been something that I found in my research. They sort of trace to the very provenance of global tax governance in the interwar period almost 100 years ago. So with respect to the first point about combating global tax avoidance, I think that's sort of the implicit assumption in a lot of these academic discussions. There's obviously a plethora of evidence and a growing literature on the potentially malign impacts of tax avoidance on growth, GDP, states' ability to redistribute, et cetera, et cetera. So I think maybe to echo Leila's point, I'd be curious if you could maybe unpack or discuss more, what you think current developments with the Biden administration, the G7 and G20 endorsements, reforming the global tax system, et cetera, et cetera. Some have posited, Gabriel Zucman famously on Twitter a few weeks ago said, the proposals put forward if fully enacted would completely eviscerate the tax haven model altogether. So I guess just generally speaking, I'm curious, how would you factor in current political developments, if at all, into the discussion? The second piece, and you did touch on this, is sort of, is the goal tax certainty and investor protection? And I think all too often the investor or the business perspective is somewhat missing in the debate. And so with respect to potential deficiencies in the mutual agreement procedure, I think here you can maybe make the case if the the system is very inefficient, it's sort of backlogged, maybe there's a taxpayer interest in having some kind of reform done or having alternative fora. So I'm curious if what kind of evidence have you found about the maps, and what does that tell you? I say this, of course, Professor Chess in his writings, and also earlier he's spoken of this sort of triple need, or this idea that the deficiencies are somewhat intuitive. There's no guarantee of arbitration. Arbitration may not occur. Maps are often confidential. But I'm just curious if you've found any kind of empirics. I myself have looked at OECD research. I think as of 2018, there's data available on how many outstanding cases there are, et cetera, but I feel the empirical picture is somewhat murky. So just curious if you can maybe explain or discuss the sort of empirics you've come across. Another piece as well, and I fit this in under sort of the investor perspective, is you talk about vertical cases, and so I wonder in the ICJ context specifically with these vertical cases, if I am to understand correctly that aggrieved taxpayers or foreign investors would not necessarily have standing, do you think that might be a potential issue, and might that be offensive to tax justice generally from the perspective of business? Third, and I think this might be implicit in the various different presentations today as well, is have you accounted for any potential conflicts of norms? I think we've learned today, there are various different potential fora where we can discuss tax. ISDS certainly, I mean, the maps are, I guess, kind of the intended format. But do you think that there are conflicts of norms, and have you potentially accounted for that in this piece? And then finally, putting my political scientist hat and taking off my lawyer hat for a moment, just and to echo maybe Leila's points as well, I'm curious if you've considered kind of the political viability and the interdisciplinary perspectives of political science. To echo Leila's point, I think if you look at the historical record and even current developments, one finds that self-interest and hegemonic power in the international system often shapes the global governance processes, which in turn shape the architecture or the structure of legal fora and the way that enforcement is done. So I'm just curious if, maybe this ties back to one of my earlier points, if you think the current political environment might potentially be conducive to this sort of, the ICJ as a potential forum. But other than that, I hope I didn't seem overly critical. I quite enjoyed the paper, and I look forward to your responses.
Thank you, Michael. Celine, do you think you can give some answers or comment on the comments that were given to you in, say, 2 minutes?
Yes, likely so, because a lot of very good questions and very much on point. They will help me to make this a better piece. And a lot of those points I don't have immediate answers to, so I think I can help to let this session not get too long. So Leila, thank you for your comments. I think if I understood your question correctly, you're mostly interested in a bit more on the question of sovereignty before the ICJ, and this core that taxation is in this yeah, so taxation being at the core of state sovereignty. I tried to be smart about it specifically in this presentation and to confine it to tax treaty disputes specifically because of this reason. There's a huge domaine reservé still for any kind of tax issues, and I don't think any of this will change. And I think if it were to change, or if states try to, we'll actually see how important taxation is for statehood and for and that it's a hot potato that the ICJ specifically wouldn't want to touch. Clearly, I can't speak for anyone in this building right now, but I can't see anything other than very much interpretation of treaty issues ever being part of the ICJ case law, unless there's a revolution in here, which doesn't. No one hopes clearly, and doesn't look like it. But I will make sure to address this issue also in the finished paper. Yeah, which clearly is a very interesting question, much more interesting than just the nitty-gritty of treaty interpretation, which we hear so much about. Much sexier to hear about the actual core of taxation. Michael, thank you very much for the many points. I took note of all of them, and I will try to address all of them. Most of them I have no immediate answer to, because they would require a kind of empirical research, a kind of empirical data that I haven't found yet, and I haven't seen out there specifically in relation to mutual agreement procedures. I think we know that there are certain volumes out there that by Strachey, I think, published one where there's some information from the domestic context and what tax lawyers think about mutual agreement procedure and their transnational relations. Yeah, so other than anecdotes, I have not found any empirical data that would be helpful for me to have a baseline against which I could evaluate this normative question of ICJ involvement. If anyone has information on this, or insiders or leaks I haven't seen, I would be very grateful for that. Conflict of norms, I have not yet addressed in the paper, would be an interesting point, specifically conflict of norms when it comes to jurisdiction, I believe, because I am not going to have any space to address substantive issues of tax law in this paper. And I think one of the interesting questions will be the ECMEA question, because many of the compromissory clauses or jurisdictional bases that I found do involve the European context and might involve this. Yes, and then I was wondering about the current developments too, because I do have the hope that international tax law will become more interesting among my peers, which are public international lawyers, because of the current political climate that you referred to. And I think it's very exciting, and I can't see how people are not yet writing thousands of papers about this with regard to public international law. However, no one has in those in any tweets or in the most recent developments referred to the ICJ at all. Not to my knowledge, I looked for any such references. So neither in the Biden context, nor the G7 context, nor the OECD have I seen any reference to an appetite to use the ICJ for dispute settlement. Maybe for good reasons, maybe people just didn't think about it or didn't even connect the two possibilities. Maybe because we have competing courts that might make more sense to look into such issues such as the CJEU. Many reasons why this could be the case, but yeah, this is why I did not address it in my draft paper yet. Sadly, I haven't found any basis to even suggest that states might start thinking about the ICJ in the tax treaty context. I see I have taken more than 2 minutes to respond. I'm sorry for that, but thank you for the great input. Very helpful.
Right. Thank you, Celine, Leila, and Michael. It's almost the end. It was really excellent. I think I truly enjoyed these 4 presentations. We were a bit afraid that 3 hours for 4 presentations could be a bit too long, but in fact, it would be very easy, I feel, to continue the discussion. I just want to say that we, Irma and I, will continue working with the 4 speakers that you could hear today, and also 3 other speakers that presented in previous webinars in this series, with the objective to publish a full special issue in the Leiden Journal of International Law in the summer 2022. So what you could hear today is really a first draft, a first series of ideas that our colleagues wanted to test and present. And for that, we are very grateful to the discussions for the feedback and criticism and further insights that they could share. And the same is true for the participants who have raised a number of very good questions and made very interesting comments that will help refining the papers as we move forward. So we have a few months to go before this final output that we will be happy to share with all of you in due course. In any case, we'll keep you all posted on this special issue, because that should be something of interest for many scholars, practitioners in the field. I'd like to thank again our speakers for their very interesting and stimulating contributions. Thank also to the participants for the valuable discussions. It's time to close this 3rd webinar. Let me hand over to my co-organizer, Professor Mosquera, for the final words.
Thank you so much, and thank you to all the speakers and the discussants and the participants of today. It's really a challenge to be 3 hours in Zoom, and it's the 3rd time, and we still have 2 to go. So what happens next week? Next week, Thursday, 2 p.m. to 5 p.m., that is Dutch time, and I don't know what time is in other regions of the world. We will discuss tax incentives. We have already discussed that in the past, last year in the GLOBTAXGOV, but we think that these tax incentives also gives an important view on what does it mean from an investment, trade, and tax perspective, and definitely in terms of the global minimum tax. So we will have Simon Everett from the University of St. Gallen, is Professor of International Trade and Economic Development. We have Hania Kronfeld from the World Bank, Pasquale Pristone from the IBFD, Alexander Redhead from the Intergovernmental Forum on Extractive Industry, and Liz Johnson from the Colombian Center on Sustainable Investment. And then the final session, that will be 1st of July, and that will be a policy making session. And there we have Marion Jansen, Director of Trade and Agriculture from the OECD. We have Howard Mann, expert in international investment law arbitration, who has been also following us through all these sessions. Michael Leonard from the UN, and Cory Hiller from the IMF. So hopefully you can join us also next week and the week after, and looking forward, and have a nice evening and have a nice afternoon for everyone. And thank you so much. Bye.
Thank you. Bye.
Thank you. Goodbye.
Bye.